It's anticipatory bail application. The case diary has come, but notice on the respondent number 2, madam. We have taken steps through the office of the PP as
Yes.
well as choose people.
Notice is not complete.
Not,
Case diary has come. So you can take instructions.
we'll take
Right.
instruction, madam.
So the case diary has been received, item 48. Case diary has been received, but the notice upon the informant not yet complete. The prosecution shall take instructions regarding the same. Retain the case diary. List on.
7th, madam.
11.
You keep the case diary. Don't send it back. Next Monday, 11th. What will be the date?
11th, madam.
11th.
I'm deeply obliged.
Please, Your Lordship. Lordship, take to mention item number 29, 30, and 44, Lordship.
29, 30, and 44.
For Lordship. The lady Vendor had some personal difficulty, Lordship. Kindly list on 7th, Lordship.
Scan copy, right? 44. It's the same.
29.
Okay. Write that only. No? If, 29 scan copy is also not received. No? 29, the learned counsel for the petitioner seeks an adjournment. However, scan copy is also awaited. Issue reminder. The list next Monday. You want it? When do you want it? Next Monday.
Lordship, only on 7, Lordship.
7th. We can fix it, but I don't know whether it will come or not. List on 7/5 and 30 scan copy has
TCR.
been received. TCR has been received. 30.
Okay,
The
fine.
learned counsel seeks an adjournment for the same. Scan TCR received. List on 7/5. Okay. And AB, these are separate matters or same FIR?
2 is same, 44 is separate, Lordship.
Or 44 is separate. 44 you have
44 malat CD received.
did you receive?
Second, Lordship.
Okay. You are on interim.
Yes, Lordship. I want.
The case diary is received. The learned counsel seeks an adjournment. 44. The case diary is received and shall be retained. The interim stands extended till the next date of listing. List on 7/5.
Lordship. Item number 41.
One. Case diary is not received. Issue reminder. Interim is there. Oh, sorry, you're for the other side, friends. The interim bail stands extended till the next date of listing. When should we fix it? 12th? 12/5? Tuesday?
14 or 15, Lordship.
14.
Highly obliged.
Okay, please, Your Lordship. I beg to mention item number 31.
Yeah.
Adjourned method to the engaged counsel is unwell.
Bail application, item 31. Place for adjournment. And TCR has been received. List when you want.
On next, anything on the next week.
Next week. So on 12th. On this side. Okay. Who is coming now?
Yes, Lordship. I beg to mention item number 37, Lordship.
Yes.
Item number 37. Lordship, the senior engaged counsel out of station, Lordship.
Hmm?
Senior engaged counsel out of
CD also not given.
Learned counsel seeks an adjournment. Case diary is also not received. Issue reminder for the same. Interim is there. Interim is there. Interim bail stands extended till the next date of listing. Right order dated so and so.
14th
You have not taken the date, I think, huh? Madam. Please take the date.
or 14th of May.
14th of May. That's okay.
I would like to mention for listing of an AP, Your Lordship. And this is a 1/6, Your Lordship. Highly obliged, Your Lordship.
To mention item number.
Hmm?
To mention item number 39, Your Honor.
Case diary is not received.
So,
39.
perhaps in this case, not call on 8/1/26 adjourn, subsequently also adjourn.
Shall we wait
Take
for the
one.
matter to come up? Then should we wait for the matter to
My
come?
lord, just,
Otherwise, I have to
check-
see the file.
we have to-
Only adjourn this matter for the day.
Earlier also to adjourn by, my lord,
File to have
39.
39. Just hold on. Any other mention we can take? Wait.
Item 42 may be possible for that.
Item 42.
42, my lord, yes, 42 CD available.
Possible for that, yes, it may be retained.
Where do you want it?
It next week.
Interim is there. Interim is not there. Case diary is received. The learned counsel pays for an adjournment. Full stop. The case diary may be retained. List on 11.5. This one was, your matter was item, which one? 39. No, CD not called.
CD not called.
CD is not called.
Simply adjourn, my lord, we don't.
Okay. We'll have to call for the CD. Okay. CD is not called. Otherwise, it will keep getting delayed like this. Call for the case diary of Badarpur PS case number 76 of 2020. This is a registered case, but investigation is completed.
So here, charge sheet submitted. PCR has to be called.
I see. Pertaining to, along with
Special and
the scan copy of the special NDPS case number 37 of 25 from the court of the learned special judge Sri Bhumi, comprising case diary of Badarpur PS case number 76 of 25, charge sheet and other relevant documents. This is the matter on 13, 11, 12, 13. 13.
Yeah, please. My lord, this is second bill application, my lord. I
Sure.
am behind the bar since 46 days. But only allegation against me will come section 317. My lord, that is receiving.
What's
insolent
that
property.
Gosala matter? No?
My lord. 46
Investigation
days,
is
my
not
lord.
complete. Huh?
46 days. Kindly consider length of.
Otherwise, my lord, these cows were, my lord, just stolen from Gosala.
Yes, yes. Get the, it might be completed also in the meantime. Short date, no? Get the case diary. Which Thana?
Jalubari.
Jalpuri? When can you get it? Day after tomorrow or Thursday?
After tomorrow.
7. 7.
The earlier bail petition was rejected on 7/4/2026. Call for the updated case diary. 7/5/2026. List
Tell
on
you.
7/5.
Item number 2.
Made please, your lord, submit a regular bail, my lord.
Yes.
He is in jail for last 54 days.
Okay.
For 2 days or more, it will be 54 days, my lord. And last occasion, they were asked to file affidavit and accordingly they have filed objection, my lord.
File an affidavit.
File
CBI has
objection, my
filed.
lord, and my submission, sorry, lordship, my lord, I am not going to the merit of the case, my lord, that right present now. Already, my lord, he is in jail for 54 days. And my lord, your lordship, kindly see the what allegation. Allegation is that, my lord, he is bank employee working in the State Bank of India,
Mhm.
and he's a loan manager. So allegation is that, my lord, in the name of my lord, loan application, he demanded 8,000 rupees from that person, my lord. There are 2 applications is there.
Mm.
So now at this stage, my lord, I am not on merit, my lord, but only on the, my lord, your lordship, kindly see the case, that length of detention. I am an employee of the State Bank of India, and already, my lord, because of my detention, my lord, my suspension has been, my lord, order
Yeah.
has been passed.
Mhm.
And necessarily, my lord, because after 48 hours, it has to be, my. So, my lord, there is no chance of, my lord, tampering the record, my lord. I am an employee of the, my lord, the State Bank, there is no chance of, my lord, hampering the, and
Case diary will be necessary. Right? You file an objection, right?
Yeah, file
Case
objection.
diary, can you produce the case diary? Huh?
No.
Day after tomorrow?
Day after tomorrow.
Tomorrow? Is it okay? Okay, let us see the case diary, because case diary has to be seen, right?
My lord, correct, my lord, no problem. All right, my lord, day after
Also,
tomorrow.
and then we consider the
But
length of
already, my
detention
lord,
also.
case diary in last occasion, my lord, they have called for, my lord. In fact, my lord, filing case diary and my lord, affidavit, case diary from Gauhati, my lord.
Achha, so the case diary should have been called anyway. Heard TJ Mahanto, learned senior counsel, and M. Kumari, learned retainer counsel, CBI, full stop. The in the meantime, the prosecuting agency / CBI has filed an affidavit in opposition. Full stop. However, proper adjudication of the matter, call for the case diary of, it is under investigation at the moment.
Charge sheet is going to be filed within.
So anyway, so, okay. So call for the case diary of RC number so and so, huh? From the CBI. The CBI is also at liberty to submit a status report of the investigation. We'll come to know about that. Okay. List on day after tomorrow or Friday?
after
On Thursday.
Day after tomorrow, my lord.
Day after
Every day
tomorrow.
after, because already, my lord, he is in 54 days, my lord. On 6.
Okay, madam. Okay, 6.
Right, please, your lordship. Lordship, as on today, almost 400 days behind the bar.
POCSO.
No, your lordship. Under sexual harassment and criminal force and all these things. Lordship has earlier considered and said that let the prosecution witness be examined. Your lordship. But unfortunately, on last 5 occasions, your lordship, not a
It was
single
not
witness
completed.
has turned up on last 5 occasions. Last it was, I have annexed the orders also. And on last 24th of April, the date was fixed, but not a single witness has turned up.
So is there, my lord, TCR latest status report will be called for?
I think-
TCR should be available here, right?
Oh, sorry, your lordship. I think I am in item number 5. I'm sorry.
That's why it's POCSO matter, this one.
I'm sorry.
Okay. Okay.
Lordship, may I kindly take up my matter to
After some time.
tomorrow?
Tomorrow.
It's filed by. It has been called.
Your good name, please.
My lord, yes, but that case may be, my lord, here ultimately notice has to go, my lord. In another case.
Oh,
maybe
fresh
no.
file, no? Freshly filed.
My lord, yes, freshly, but this is motion, my lord.
So we can, okay, we can save time in the meantime. We can fix a date and save time because of this earlier bail petition. Your good name, please, ma'am.
I'm HD Das for the petition.
Earlier bail petition was rejected on 8/4/2026. Being a POCSO matter, issue notice upon the respondent to the office of the learned public prosecutor and to be executed through the concerned police station. The prosecution shall take instructions regarding the service. The informant is an SI, however. He's a SI. By name, they have implemented, but SI. But the process should be faster. You can quickly take instructions. And if he instructs you to represent him, most probably he will.
My lord,
Then there is no problem. Okay, formality will do.
my lord, regarding TCR may be called for.
But TCR should be available from the earlier round.
Then it can be tagged, my lord.
Yes. The registry shall check up the TCR which was called for in connection with the earlier bail petition, and if it is available, it may be put up for adjudication of this subsequent bail. Meanwhile, call for a updated scan copy of updated TCR from the learned trial court after the date of 8/4/2026, right? Including copy of depositions, etc. List the matter on when should we fix it? After a couple of days? After a couple of days. That will take a.
After 2-3 days, that matter may be taken at tomorrow, my lord, the already fixed matter. This matter may be taken after 2-3 days, my lord.
Same, tomorrow matter is same FIR. Same FIR. But tomorrow this will not come. Instruction, your service instruction may come if you take, if they take steps.
I'll take, my lord. Okay, maybe.
Okay, but TCR will not come. TCR will not come, however. Anyway, I think let us fix this on Friday and hear that matter tomorrow. Okay, these are different, yeah, though it's same. Based on Friday, 8/5.
Much appreciated.
Yeah, please, your lordship. This bail application has been filed against the lordship FIR which was lodged on 25 against a 76 years old lordship. The petitioner is 76 old, and the allegation is that lordship there was a penetrative sexual assault. But as per the doctor's report, lordship, there was no clear evidence of any penetrative sexual assault, and as per the forensic report also, lordship, it reveals that lordship there was no such stain or anything.
Okay. It is a charge sheeted case, right?
Yes, your lordship. PW2 3 has already been lordship examined.
Victim has been examined.
Yes, victim has been examined. Complaint
7 years old girl, my lord.
Case number 20 is the lordship medical report. Doctor lordship. And the allegation lordship for the statement of lordship victim.
Anyway, so still, I think we'll have to go through the formalities. On examination and chief, she has implicated prima facie. Anyway, so that will come later. Right? Third, so and so on. All for the scan TCR of special POCSO case number 74 of 2025, rising out of Bihali PS case number 76 of 2025. On the court of the learned special judge Biswanath Saril. Biswanath. Stop. The petitioner shall take steps of notice upon the respond number 2 and to the office of the. When do you propose? Within 13th you give 11, 12, 13. 1 week we can take a chance.
This, my lord, it has, registry it will take some time.
If we take steps, expedition,
15, my lord.
14 or 15. 14.
Highly obliged.
Made please, your lordship. We're almost 400 days behind the bar, more than a year, lordship. Charge was framed on 6th of August 2025, and till date, your lordship, not a single witness. Lordship has earlier considered the bail petition, your lordship. I have annexed the order at page number 38. Relevant page, lordship will find at page number 40. That termination of victim and on 28/12/2025. Thereafter, your lordship, on 4 occasions, the case has been listed, but not a single prosecution turning up, your lordship. I have annexed the orders also from page. Otherwise, lordship, on merits also, your lordship, medical report does not support the case.
Investigation was very serious, so at the earlier round, we
That is-
rightly or wrongly did not consider.
Lordship.
Yeah, so
Under trial prisoner and witness from page number 29, lordship may see. I have annexed the orders, your lordship.
victim has not appeared.
Nobody is appearing, your lordship. Five times the case has been listed. Page 29, lordship will see on 5/12/2025. Yes, someone was issued to the witnesses. Then on 22/1/2026, PWs were absent. Then on 16/2/2000, PWs were absent. Then on 16, PWs were absent. On last occasion on 17/4, your lordship, on I have been
Anyway,
inspected on
so-
24/4 also there was a date. On that day also they were absent.
Earlier bail petition was rejected on third so and so, 8/12/2025. First of learned, Mr. Roy, learned counsel submits that petitioner is in custody since 2/4/2025. And though the matter has been fixed for prosecution evidence over several dates, but no witness has appeared. Full stop. Call for an updated TCR after 8/12/2025. Well, sorry, I call updated TCR pertaining to the dates after 8/12/2025 of this number What is the special case number?
Lordship. Yes,
It must be here. Huh?
yes, sessions case number 139 of 2025.
Sessions case number 139 of 2025, rising out of Badarpur PS 64 of 25. From the Court of the Learned Additional Session Judge, Sribhum. Good stuff. List the matter on. Next. 14.
Oblige, Lordship. Regular bail application, Lordship, affair case 12, Lordship, petitioner is behind the bar for 76 days and case is registered under section 22C of NDPS, Lordship. This present petitioner is arrested, Lordship, on 17/2, Lordship, the forwarding report at page 15, Lordship, and he is arrested on the statement of the prime accused, Lordship. Nothing was recovered from his. Lordship, kindly see the relevant portion, page 17, Lordship. Page 17, middle in the para, Lordship. 17, during the course of investigation, it reveals from the statement of the arrested accused persons, namely so-and-so, so-and-so, one, Zakir Mia, this petitioner, has supplied them and seized so-and-so. Accordingly, Zakir Mia was apprehended and interrogated thoroughly during the interrogation, and he also confessed that he had supplied the seized so-and-so tablets. Only the statement of the prime accused, I was arrested, Lordship. Nothing was recovered from my possession, Lordship. And the prime accused arrested on, Lordship, on the day 15/2/2026. And acting on specific information, the raid was conducted, and these items were huge quantity of the drugs got from the
Java.
That you will reveal, my lord, Siddhi may be called.
It's under investigation.
Yes, sir.
Call for the heard. Mankasar PS case number 28 of 26. Petitioner was arrested on 17/2/2026. The Learned Counsel submits that the accused petitioner was arrested on the basis of statements of co-accused and that there was no recovery from him. List the matter on
13th.
30.
Prohibitive bail. I am behind, in present case, I am behind over for 1 year, 3 months, 17 days.
Commercial quantity.
1 year, 3 months, 17 days.
It's under, trial is going on. Trial is.
No, Lordship, I am coming, Lordship. Kindly see, Lordship, page 61 is a scissor list, Lordship, page 61. The type copy, Lordship. First comes scissor list, name and address, Surjit Singh, Lordship, recovery 934 kgs of Lordship ganja is recovered from one Surjit Singh, Lordship. I am not Surjit Singh, Lordship. There's a recovery was made on Lordship 3/8/2024. Now, Lordship, page 20. Page 20, kindly press Lordship, page 20. Page 20, Lordship.
Yeah.
Paragraph 6, Lordship. From top, Lordship, line number 10, Lordship. And
You read it. I'll try
because
to.
there was only one person in the truck who was its driver. Now, Lordship, last line, Lordship, the driver of the intercepted truck bearing SO number so and so introduced himself as Surjit Singh, Lordship. Surjit Singh, Lordship. Now, Lordship, page 34, Lordship. Page 34. Page 34, Lordship, second paragraph, Lordship. Page 34, para 29. That during investigation, arrested accused Surjit Singh had stated in his voluntary statement that on 3/8/2024 that he came in contact with Rup Singh. Now, let's say I am Rup Singh, Lordship. I have been arrested on the basis of the statement of Lordship Surjit Singh. He was arrested on 3/8/2024. I was arrested on Lordship 17/1/2025, Lordship. Now, Lordship, in present case, Lordship, final complaint has been submitted on 29/1/2025.
So
In that,
the petitioner's name emerged from the statement of Surjit Singh.
yes, Surjit Singh. Now, Lordship, if I come to the 47 notice, Lordship, it is page 66. Page 66, Lordship, it is certified copy, Lordship.
Page 66.
66, Lordship. See, Lordship. Very simple notice, Lordship, no grounds has been inserted, Lordship. It is the written may I read, Lordship. You are hereby informed that you are arrested in connection with the above reference case and violation of the NDPS Act 1985 in connection with the seizure of 934.510 cases of ganja. The case is non-bailable, so you will be produced before the Honorable Jurisdictional Court. You may submit petition before the Honorable Court for your bail, Lordship. 47 also not complied with. I have been arrested on the basis of the statement of the Surjit Singh. He was arrested in the year 24. I've been arrested on 17/1/2025, Lordship.
Mr. Chaudhary.
Lordship, even 48 not provided, Lordship. 48 not provided memorandum as well. In memorandum of arrest, Lordship.
Let's check on the records.
Okay. Lordship, memorandum of arrest, it was not attested by the single witness, Lordship. Lordship, I want to submit one order, Lordship, passed by this Honorable Court.
But we'll have to see the record a little bit.
Lordship, at least.
Otherwise, commercial quantity, we have to see the record. Yeah.
The Lordship will come to page 35 for a moment.
Yeah. Yes.
Now, without going into the details of the record,
CDR analysis.
no, without going through the details, what transpires from the materials on record is, Lordship, the person who has sent the goods to Surjit Singh, and he even paid Surjit Singh for that your Lordship will find at page 35, Lordship has noted paragraph 32. Hereafter, Lordship will come. Paragraph 35. And then 36, Roop Singh himself, he admits that he has been in trafficking business for the years. Last 14 years. And now I take your Lordship to page 44. 44, Paul Roman 1. Accused Surjit Singh met Roop Singh 7 months before the season at the Gurdwara in Dhubri, Assam, and about 45 days before the season, Surjit Singh and Roop Singh met again at Lalmati Gurdwara. There, Roop Singh contacted Surjit Singh for a compensation of 3 lakh rupees for trafficking and delivering the ganja to Malda, West Bengal. So he was the person who was sending it through Surjit Singh. And another paragraph which I want to show from his records at page 49, that there was financial transaction that is revealed. Page 49, that Roman 4, financial transaction, and so. So, Lordship, that he is involved, that is beyond doubt. Now we have to see the technicalities, whether 48, 47.
You should have written some more in the notice.
Yes.
47, they should have, because this is now January 2025, isn't it? These are serious cases, so they should not make mistakes.
Perhaps the TCR, Lordship,
Yeah, that will.
the connected matter, my friend appeared, Surjit Singh, that is bail application 408 of 20 has been rejected. Perhaps the TCR is there, Lordship.
There. We can.
Was there.
Lordship, he is the person from who it was recovered. He was arrested in 2024, Lordship. I'm not in that track, Lordship. Lordship, I have placed some orders, Lordship. Kindly peruse the, I have marked as
That's
A.
true, but TCR has to be seen, isn't it?
Yeah, Lordship. Order A.
Serious matters. These are.
Medicine, Lordship. Order A, Lordship. It is when 47 was not complied with.
Yes,
this
that's
honorable court,
okay.
Please
That's okay.
get
That's
the
okay.
interim protection at least, Lordship.
Okay. But I think.
Lordship, and one order I have been placed, Lordship. I have marked as C, Lordship. This is Sakidul Hawk, Lordship.
Yes.
Kindly see, Lordship, passed by this honorable court, Lordship. It is, Lordship. Well, kindly see the paragraph, Lordship, 7, Lordship. Passed by this honorable, paragraph 7. After the law laid down by the Honorable Supreme Court in case of Tufan
So
Singh
that's
versus-
okay, but yeah, in
Yes.
this case, prima facie, there are other materials also, CDR and all. I'm more concerned with the notice under 47. If 48 was not complied, because there are other financial transaction materials prima facie, and as well as CDR is there. So we will have to see. So since the TCR is here, no problem. We can ask
Lordship,
registry to
that
put
was
it up.
found in 408 of 26.
Put it up.
If, their lordship.
Put it up. The petitioner is seeking regular bail under 483 BNSS in connection with NDPS case number 1 of 25, arising out of NCB Gauhati crime number 8 of 24, and the pending before the Court of the Learned Additional Session Judge Rongia. Full stop. The Learned Counsel submits that petitioner has been arrested on the basis of statement of co-accused, semicolon, that there was no recovery from him, semicolon, that notice under 48 BNSS is inadequate, comma, while notice under 48 BNSS was not provided. First. On the other hand, the Learned Deputy SCG submits that there are materials, there are also materials regarding CDR, incriminating materials from CDR analysis as well as financial transaction. Call for the registry may put up the TCR of the case, which was called for in connection with BA number
408 of 2000.
408 of 2026,
That has been disposed.
which was disposed of. You have the date of disposal.
Yes, lordship, it was.
All data may help.
8/4/26.
And is disposed of on 8/4/2026. That's one advantage of scan TCR, not send back. So it will be there. It will be there.
But the trial is yet not initiated, the charge is not framed, Lordship.
No, no.
The interim bill may be again.
No, not possible.
Like-
This is the matter. When should we fix it? Thursday? When would you suggest?
Eight, lordship.
About it, who might have you?
Lordship, this is regular bail application, my lord. Arrested on 9/3/2025, my lord. Today it is 54 days, my lord, by DRI, my lord.
Yeah, Madam, you're appearing for the DI.
I was found with a gold, fake gold, my lord.
Fake gold. Nice.
No, it's original gold. Worth 996.38 gram.
Code has been under Custom Acts.
And all the offense are, my lord, 7 years of.
Under Customs Act.
Acts.
Customs Act.
This 60 days offense, my lord.
Caesar is 110, 110, Caesar.
It is 54 days, my lord. This is
60 days offense.
offense, my lord.
Section 110, 1 you have a case diary or something? Case diary?
Call for.
All for us. No, case diary is prepared in
Yes.
this case.
In this-
Yes. Heard Mr.
It can be on 7th, my lord, because on 8th it will complete 60 days, my lord.
On 7. 8 also, but okay, it comes. No, I have no problem. 483 be an application. Call for the case diary of DRI case number, so and so. Petitioner was arrested on 9/3/2026. List on 7/5.
7/5. Published.
May I plead your lordship? Your lordship, it's a regular bail application, your lordship. The case is under section 18B29 of NDPS Act, your lordship. The case is at the trial court, your lordship, is pending at the trial court. Therefore, kindly scan copy may be called for your lordship.
Yeah, from here, go.
Scan copy may be called for your lordship, yes. It's Karbiang, your lordship. Can it be fixed on 18, your lordship?
18.
18.
Okay, no problem. Your good name, please. Heard. Okay, proceed. Council, we learned additional PP. Call for the scan TCR of NDPS case number 18 of 2026 from the Court of the Learned Special Judge Kabianglong Different. Within bracket, Khatkati PS case number 123 of 2024. It's not commercial quantity, not commercial,
Intermediate quantity.
intermediate quantity. So the petitioner was arrested on 14/12/2024. List on
You want 15 minutes.
18.
18.
18/5.
May I please, Your Lord? This is a regular bail, my lord. Petitioner arrested on 31/3/2024 with 106 gram of heroin, my lord. He was registered under 21B of NDPS Act, my lord. Your
Okay.
lordship may kindly peruse the FIR address. Is that, my lord? Page 14, my lord.
GRPS.
Right.
GRPS.
Not at such. That's it, one.
Not sir. Was apprehended on 30th, my lord, but arrested on, my lord, 31/3. That is after 24 hours later. That is arrest memo is, I have. also-
What is your CD may be called for madam, next week, madam.
That will be necessary. Arrest memo, yes, you wanted to show.
Page 17, my lord.
It's in 31, 10 PM.
Column number 7 here, it is mentioned 31/3/26, my lord, at 10 PM. And he was apprehended at 8:05 PM, my lord, on 30/3/2026.
On 30.
On 30th, my lord. Last line, my lord, your lordship, in the FIR last line. Thereafter, all the seized article along with the apprehended persons were brought to the Gauhati PRPS and handed over the seized article to list ASI depends such and such, commercial. So he is on custody from 30th, my lord.
Anyway, we'll have to see this aspect also. To see this aspect also. There is investigations going on.
Yes, for.
GRPS is here only. Can get. Call for the case diary of Gauhati GRPS case number 68 of 2026. The petitioner was stated to have been arrested on 31/3/2025 at 10 PM. It's submitted by the learned counsel that petitioner was detained on 30th March itself and produced before the magistrate after the stipulated period of 24 hours. Stop. Nevertheless, the learned additional PP, the perusing the case diary shall also address the court on this aspect as well. This is the matter on.
14 madam.
It's okay for you. 14 or little.
12,
Let it be on 13th.
13 madam. Okay then.
Please, Your Lordship. Regular bail application under section 483, Lordship. Petitioner has been arrested 15/3/2025, Lordship.
Right.
Matter related to POCSO, Lordship.
Okay. He was arrested on.
15/3/2025, Lordship.
You kindly take the steps.
Lordship.
Got that. Third, the learned call for the
TCR madam.
scan TCR of POCSO 81 of 25. Rising out of Narayanpur PS case number 16 of 2025 from the Court of the Learned Special Judge North Lakhimpur. Petitioner was arrested on 15/3. Steps of notice upon the informant R2 shall be taken. Again. List on 14.
14, Lordship.
Or madam, 18 madam, notice
18 Lordship, I am not available, Lordship.
15, my lord, 15.
Okay, 50, so.
Highly apologize, sir.
That is number 12. Right, please, your lordship. One of the petitioner was arrested on 12/11/2025. Today is 173 days. And my lord, charge sheet was submitted in time, my lord, and one PW already examined.
Examine.
Yes.
This from
So Gwalpara, my lord.
Gwalpara, Bongaigaon,
Sorry, my lord.
Bongaigaon?
Gwalpara, my lord.
Gwalpara. Session Judge Gwalpara.
Yes, my lord.
Third and then Learned Counsel. Call for the scan TCR of Special NDPS 4 of 2026 arising out of PS case to delay. How? Gwalpara PS case number 213 of 2025. Petitioner was arrested on 12/11/2025. List on
18, my lord.
it's not late for you, it's okay. I have 80.
That please, lordship. Well, in this case, now petitioner has approached before this honorable court second time, lordship. My lord, kindly see the FIR as 11 laws.
Just a minute.
Having land dispute, my lord, there was altercation between two parties, lordship. The informant side, my lord, came to occupy the land, lordship, to construct, my lord, home therein, my lord, and there was a, my lord, quarrel, lordship.
When was it rejected last?
Reject 140 on, lordship, best applicant. My lord, mainly on the ground of, my lord, stage of investigation, lordship.
Mhm.
My lord, paragraph 9, lordship of this, of your lordship's order, lordship.
Okay, no. Rejected at this stage.
My lord, other aspect, lordship, kindly see the FIR language of the FIR, your lordship, kindly peruse, lordship, at page 11, lordship.
We get the updated case diary.
My lord, updated case diary as well as my cross case is there, lordship. Because this is a, my lord, case, my lord, where, my lord, a person was died, lordship. My lord, the injured, my lord, initially, my lord, had taken treatment AIMS, lordship. On the same day, lordship, he was released, my lord, after having medical treatment, my lord. My lord, my lord, the petitioners, my lord, please that he expired in the subsequent event, lordship. He had gone home, like thereafter he, my lord, was unwell and my lord, admitted in local civil hospital, lordship. And wherein he was, my lord, declared died, lordship, death, lordship. Now, my humble submission, my lord, in both the cases, my lord, there should be, my lord, common, my lord, independent witnesses, lordship. To, my lord, those justice, lordship, the case there is in both the cases may be called for, my lord. On the other hand, lord, the injury report from AIMS, that is very crucial, lordship. Our case is, my lord, he expired, my lord, in subsequent event, lordship. My lord, because on the, my lord, on last occasion, my lord, my lord, London PP expressed that there were, my lord, 11 injuries, lordship. In such a injuries, my lord, he ought to have been, my lord, under coma in the AIMS, lordship. That was not there, lordship. So in AIMS, my lord, he was not serious, lordship. That is why, my lord, injury report from the AIMS is very, my lord, necessary. But that may also be called.
You just write like that, huh? Page 42.
Anyway, my lord, 42, 42, my lordship, a detailed order, my lord, because there are sufficient materials, that is why it is rejected, my lord.
Anyway, so
And there is no change in circumstances, my lord, because as, my lord, here the case is that they were, my lord, several injuries and they were, it's a cold-blooded, my lord, assault, and ultimately the person died, my lord. A specific observation, and there is also eyewitness as per your lordship's last order, my lord. So circumstances will not be changed, my lord, even if we call both the CDs, my lord, as per my lord.
you are for the informant.
Yes, sir.
My lord, on the earlier occasion, my lord, the case diary of in other cases was not, my lord, perused by this honorable court, lordship.
You have to
That
go
is
by
pretty much-
mainly by this case diary, but of course
common witnesses, my lord,
we
should
can
be here,
still
lordship.
have a look to have an overall picture. We can, but mainly we have to
In
go
both the
from
cases,
the
lordship.
thing. You just write from page 42 and heard Mr. M.H. Ahmed, learned counsel for the petitioners, and MP Goswami for the learned additional PP. Your good name, please?
R. Islam on behalf of M. Ali.
R. Islam, learned counsel for the informant. second para you lift. Earlier bail petition was rejected on 6/4/2026. Mr. Ahmed, learned counsel submits that at this time the case diary of the cross case may also be called for, along with medical report from AIMS. As one of the contentions of the petitioner side is that that though the victim had been taken to AIMS, but he died due to subsequent events. Call for the updated case diary of Dolgaon PS case number 41/26, along with
Dolgaon 47 was.
Dolgaon PS case number 47/2026. Within bracket, you write purported cross case. Purported cross case. Shall we mention about, Mr. Goswami, shall we mention about the AIMS report also?
My lord, it will be part of the CDPR as well.
My lord, earlier it was not your lordship. That is why it is
If
required.
possible, the IO said also try to procure the medical report of the victim from AIMS, Gauhati. AIMS Gauhati, right? List the matter. Next week, you give a date.
Or that may be given was.
Next week,
Like us.
take the date. I have not given. You can suggest.
Plus even 14, my lord.
Okay.
Like us. I am sorry, lordship. Item 14 and 21, lordship. Common affair.
Same.
Same lordship.
Same. So same kind of order.
Yes,
we'll do.
lordship.
14 and
21, lordship.
14 and 21.
21, lordship.
14 and 21, same order. Write it separately, but same order.
Like us.
15. Please.
Yes.
This course is the two BNSS of 223, your lordship, and this is second time, your lordship. It may be called for
Okay.
FIR and
Updated to case diary.
lordship. Update. Is there is
So,
necessary.
third, Mr. S. Hussain, Learned Counsel MP Goswami. The Learned Counsel for the petitioner fairly submits that an earlier bail petition was rejected on 6/4/2026. Call for the updated case diary of Hajo PS case number 504/25,
With PM report.
along with PM report. Also, list on, when do you want, would you like to have?
15.
Monday, Hajo is already.
Lordship. Haju, my lord.
11 now. Monday,
Okay, my lord, let it be on my on 13, my lord. 13 Wednesday.
you want it earlier? 11.
Thought maybe since it is Haju. Okay.
11.
No.
Even now, I know. 15.
Lordship.
13.
Obliged.
Item number 16.
Please, your lordship. The 482 application, your lord. Case is registered under section 6 of the POCSO Act, 9 of the Prohibition of Child Marriage Act, and 75 of the Juvenile Justice Act. My lord, here, my lord, petitioner is the husband of the alleged victim, my lord. Your lordship will find the FIR at page 18, my lord. Vernacular at page 26. Allegation against the petitioner is, who is the husband of the, my lord, victim woman, my lord, that is, he married her 3 years ago, my lord, while she was 17 years old age. Thereafter, my lord, they have been living as a family, my lord, and on 22/2/2026, my lord, she gave birth a child, my lord. The fact is that, my lord, the petitioner, my lord, there has been a, my lord, love affairs in between them, my lord, since 2023, my lord. And he married petitioner on, my lord, 17/3/2025.
Well, she was a minor.
No, my lord. While she was major, 18 years, 1 month, my lord. Your lordship will find that Annexure 3, my lord, I have submitted one school certificate, page 29. Her date of birth is 5/2/2007, my lord. And petitioner married her, my lord, on 17/3/2025, my lord. It's purely, my lord, a consensual.
17/3.
17/3/2025. Purely, my lord, 18 years, 1 month, my lord. My lord, that's a misunderstanding regarding her age and date of marriage was arose, my lord, while she was admitted in the hospital, my lord, due to her advanced age, my lord. She produced one Aadhaar card, my lord, where her date of birth is inadvertently, my lord, recorded as 5/2/2008, my lord, instead of 5/2/2007. That was the confusion, my lord.
5/2/2008.
8, my lord. Otherwise, there is a very admitted case of, my lord, consensual relationship between two, my lord, consenting adults, my lord. We have been living together, my lord. Our newborn child was born on 22nd, this 2 months before, my lord.
Technically, it's a POCSO, so notice has to be issued.
Yes.
But if we take this view, then maybe
Some protection will
maybe-
be, my lord, till, my
Anyway,
lord, next day. my
heard-
lord.
sorry. Goswami, I'm not. Invoking section 482 BNSS, the petitioner seeking anticipatory bail in connection with Vilasipara PS case number 25 of 2026. Under so and so section, full stop. Complaint was lodged by respondent number 2. Who is the child marriage prohibition officer for that Panchayat area, alleging that the petitioner had contracted marriage with the alleged victim / respondent number 2,
My lord.
aged 17 years. Respondent number 3.
Yes.
Respondent number 3, aged 17 years, 17 years. Stop. And they also have a child born on 22/2/2026 at Dhubri Medical College. So it is submitted that the petitioner and the girl married after a long love affair, but the marriage was solemnized on 17/3/2025 after she had attained majority. Stop. It is stated and submitted that her actual date of birth is 5/2/2007, and in support of the same, the learned counsel has drawn attention to a copy of a school certificate,
Full living certificate.
school certificate, as well as
On
an affidavit
affidavit shown by the victim.
sworn by, purportedly sworn by the victim girl. I peruse the same. In both the documents, the date of birth is mentioned as 5/2/2007. Nevertheless, call for the case diary from the concerned police station. However, in the aforesaid facts and circumstances, the possibility of the girl being a major at the time of her marriage cannot be ruled out. And in that event, the possibility of non-application of the POCSO Act also cannot be ruled out prima facie. Full stop. In such view of the matter, it is directed that in the interim, in the event of the arrest of the petitioner in connection with this case, he may be allowed to go on bail of rupees 30,000 with one surety of the like amount. The satisfaction of the Vilasipara would be SDJ, Special Judge Dhubri, to a concerned learned court, and subject to the conditions that he shall cooperate with the investigation, appear before the IO for examination, shall not hamper or temper evidence.
Highly obliged, my lord.
This is the matter.
Record my prayer that, my lord, I have prayed for the CD before granting injunction.
Mr. Goswami, learned additional PP objecting to the bill, submits that at this stage only case diary may be called for first. That's okay. You can give a little longish date.
20
20 seconds. We have to make space for other matters also. 20 seconds.
26.
Highly authorized.
Item number 17.
Yes, there's a Lordship, this is the second pre-arrest bail application of the petition, my Lordship. The
Yeah.
FIR is at page 9. Name of the petitioner is not indicated in the FIR, Lordship. Although the police has arrested persons in connection with this case, Your Lordship, who has been granted your regular bail by this honorable court in bail application number 146 of 26 or by order dated 16/2.
Which is the rejection order?
The rejection order is at page 16, Your Lordship.
Okay. Robbery, right? We get the updated case diary.
Protection may be given to.
But
No, my lord, the paragraph earlier rejected.
Yeah.
I think, my lord.
The accused persons have been already given bail, Your Lordship.
maybe facts are different.
The
Maybe
regular bill.
Out of
that
the
was
two-
regular bill.
Yes, Your Lordship.
That was regular bill. Stands on you. When can you get the case diary? These are regular bill. Yes. Regular bill. Third. Is a subsequent bill petition, and the earlier one was rejected on 16/3/26. Call for the updated case diary of Abhayapuri PS case number 265 of 25 first. Before that, you just write. Learned counsel submits that two other co-accused have been granted regular bail by this court, and the copies of the same have been annexed. We also praise for interim bail at this stage. Service of the call for the updated case diary. Give a
On 18, my lord.
little earlier, since,
I'll remind. 14, my lord.
okay, what?
Published.
Item number 18.
Wait, please, your lordship. FIR also will find at page 11. There you go. The petitioner before your lordship is Srivas Roy, lordship.
Just a minute, just, gave in the earlier order, which I gave interim, not this one. Earlier one, POXO. POXO. POXO one, the notice has to be issued. No, you just write down, no, just a minute. I forgot to, notice has to be issued, no, in that, Mr. Goswami. The notice, the petitioner shall take steps for issuance of notice upon the informant to the office of PP and to be executed through the concerned police station. Notice has to be issued in that. I forgot actually.
16, my lord,
Yeah.
16, yes, my lord.
But if possible, kindly convey it to the council because he may forget also. Yeah.
Page 11 is the FIR, lordship. The main allegation is against other persons, lordship. In fact, there is no allegation against the present petitioner except stating that he produced the victim girl before the police station, that much.
Should we read the?
Lordship.
I'll go through it quickly.
With due respect, I beg to state that on 12/3/2026,
Mandal.
my minor daughter, namely so-and-so, aged about 17 years, was kidnapped by one Orup Mondal, so district so-and-so, along with some other people from Gauhati. They took my daughter to an unknown place and raped her. Regarding the incident on 13/3/2026,
Actually, I mean, it should not amount to violating this thing. But still, I've taken a liberal view. What do you say? That there is no specific bar.
on that earlier also. I
There's no
have
specific
submitted the
bar.
Delhi High Court judgment, which says that
But Delhi, we are bound by division bench. There's no specific bar.
Always
That's the only.
that it was.
But a clearer position would be helpful. Because many such situations will arise. Such situations will arise.
Obliged, lordship.
Yeah, please, Your Lordship. To application, Lordship. The present petition because is a senior citizen, heart operation patient, Lordship. And the allegation against them in during house search, Lordship, 11 number of cattle skin was recovered and told, Lordship. And present petition before you, Lordship, is a registered certificate holder of retailer business of beef selling shop, Lordship. Kindly see the page 9 is the FIR, Lordship.
Is it in violation of this
Assam cattle.
cattle? Because it has some restrictions of some area, right?
Lordship.
There's some,
If there is international border that cannot be transported.
and some areas it cannot be, no, that kind of restrictions. Anyway, page 15 is the FIR.
Page 9, Lordship.
Is 9. Is 9.
Married, Lordship. With due respect and humble submission, I have the honor to state that today, on 22/4/2020 at about 11 a.m., on the basis of secret information, the CD SP Pallasbury intercepted two vehicles bearing registration number so-and-so, at Upper Hall near Coalmine Godown, which were found carrying cattle. According as directed, I along with the PSC staff proceeded to the place of occurrence. On arrival, it was observed that the cattle were tied in a cruel manner in the said vehicle. As per direction of CDSP, Madam, the driver were asked to produce valid document regarding the transportation and ownership of the cattle. However, the driver failed to produce any such document. On suspicion that the cattle might be stolen, the vehicle along with the driver and cattle were brought to Pallasbury police station for further necessary action. During the interrogation, the driver confessed that the cattle had been taken to the slaughterhouse of Mubarak Ali, son of Salim Ali, resident of Beles Harpara, PS Pallasbury district, Kamruk. Acting on this information, allowing the PS staff conduct a search at the house and recover 11 number of cattle skin, along with the tools used for slaughtering cattle. The recovered cattle skin and tools were seized at the place of recovery in accordance with the due process. From the above fact and circumstance, a cognizable offence appeared to have been committed. Therefore, I request you kindly register FIR and take necessary action as per law against the accused person name and address Arun Das and Bima. Your present petition before you is the Mubarak Ali, Your Honor. Kindly stand page 17 is the certificate, Lordship.
This search was conducted at the house of whom?
Mubarak Ali, present
Mubarak
petition
Ali.
before. Because
Caesar list is there.
no, Lordship, there is no Caesar at the time of I applied for, but Caesar was not I think. So the FIR, kindly see the page 17 is the FIR, 7 is the registration certificate, Lordship. And name and permanent address of food business of person Mubarak all beef shop, Lordship. And kind of business is a retailer, is a retailer businessman. Now he is a 64 years old man here, no? And from 2023 to till date, Lordship, there is just I undergoing treatment for heart here. I have annexed 20.
He has a proper license according to
yeah.
you.
Yes.
Not doing illegally.
No, that is valid till up to 30/12/2028. That is very.
The actual fact can be revealed from the CD only.
Till that primary airport, there is a heart patient, you know, is the one stand in the set in here heart Lordship due to blockage of his heart, Lordship. I have annexed all the medical document, Lordship, from page.
How old is he? 70?
64 years.
64 years.
From 2023 till date, Lordship, he is undergoing treatment.
So anyway, heard so and so.
Islam, Lordship.
482 PNSS. Pallasbury PS case number 95 of 2026. That's right. The allegation in the FIR dated 22/4/2026 is that based on an information, the Pallasbury police intercepted two vehicles found to be carrying cattle tied in a cruel manner. The drivers could not produce any documents, and suspecting the cattle to be stolen, the vehicle and cattle were brought to Pallasbury PS, and subsequently the drivers revealed that cattle was being taken to the slaughterhouse of Mubarak Ali. The police searched his house and found some cattle skins and tools. The learned counsel for the petitioner has drawn attention to a certificate issued by the FSSAI, within bracket, the Food Standards Authority, within bracket, close, giving license to the Said Mubarak Ali for running a beef shop. And the license is valid till 30/12/2028 as per the certificate. First, it is submitted that the petitioner has not violated any provisions of the cattle law in Assam, and that besides being aged about 64 years, he also suffered from cardiac ailments. Peruse the annexed medical certificates. Call for the case diary. However, in the interim, in the event of his arrest, in connection with this case, allowed to go on bail of 30,000 with one surety of the like amount to the satisfaction of the arresting authority, subject to the condition that he shall cooperate with the investigation, appear before IO for examination, and shall not violate any provisions of the Cattle Preservation Act, PASAM, as well as the Prevention of Cruelty to Animals Act.
Much of that.
This is the matter on
21st of May, my lord.
21st of May, 21/5.
Item number 20.
Net period also. Here FIR is page 8, Lordship. One of the section which is registered under this case is Lordship section 8 of POCSO. And there is some allegation there, so probably notice will be required in the present case.
Yes. The allegation is against him, the third A. Ahmed, Learned Counsel. Call for Borpeta PS case number 103 of 26 under so and so section. Issue notice upon you, you make a template on that for the office of non-PP and to be executed by list. Notice upon respond number 2. List on, you work out the date.
My lord, on 15.
15.
52.
Classify the matter for time being. Senior is another.
You've given notice to the government advocate, right? Okay, we'll take it up after some time, no problem. It's a washing matter. এইখিনি কৰি লওঁ নেকি হৈ যাব এনেকে লওঁ সেনেকে লওঁ ডিছপ'জ কৰিব শুনকচোন ডিছপ'জ কৰিব লাগিলে টাইম লাগিব আৰু যদি সৰু থাকে তেতিয়া কৰোঁ নাজানো নাজানো অ'কে ঠিক আছে মাতি দিয়ক
23. Admission attempt.
Lordship, matter may be listed on 13, Lordship. We have misplaced some documents. We have applied for certificate copy.
Okay. No problem.
On 13. Lordship.
It's for learned counsel for the petitioner seeking an accommodation praised for listing the matter on you want it on 13th?
Yes.
On 13th of May.
Obliged.
List the matter on 13th.
24.
This year is also, I think it's conviction.
Lordship, my lord, before my learned trade starts, Lordship, Lordship, I am appearing for the private respondent, Lordship. And at present, the petitioner is in custody because an order was passed by the SDM North Salmara to pay maintenance to the respondent number 2, Lordship.
Distress warrant was issued.
Lordship, warrant was also issued, and person now he is in custody, Lordship. So I have to take some instruction, Lordship, in this regard regarding the judgment passed by the learned court below, Lordship.
The revision is against criminal petition. No?
Petition, Lordship, here what happened? Lordship, here what happened? Two cases are parallelly running against the same accused. The court is also same cause of action. Only one section, 498A. In PRC case also, in CR case also. One section cannot be run parallelly in the same court against the same person, accused person, against the same cause of action, Lordship. This is my case. My case is that I am praying for strike down of one of the cases.
No, that too we have in the CRPC also, isn't it? That if there's a
Yes,
same complaint has a, there's a
Yes.
complaint case and a police case. It has to be treated as a police case and then we proceed.
Firstly, Lordship, on 30/7/2022, she lodged the FIR. Thereafter, after 7 days, Lordship, after 7 days on 6/8/2022, she lodged the CR case. And now, Lordship, in the PRC, after charge sheet has filed, case starts, trial begins, and Lordship, later on, the case.
Complaint is at page.
Yes,
You just flag it.
Yes,
for
Lordship.
the
I am
next-
coming
next
one
bit.
by one, Lordship.
Let him take the instructions. You take the instructions and then I'll just flag it. Can you tell me the name and page number of the complaint?
Yes. Lordship, FIR vernacular is
I
at
know.
page number 26.
Well, 21 will do.
Yes, Lordship.
Oh.
Complaint
So,
case is at page number 32 in vernacular. In vernacular, a clear handwritten, Lordship, 32, page number 32.
32 and
And Lordship,
the type copy.
and type copy is Lordship.
Vernacular also I'm tagging.
Yes, page number 28, Annexure 2. This is the CR case. Lordship, here CR case has been filed for recovery of the speed horn. And the FIR was filed alleging mental and physical harassment along with doubt.
Street horn is a different cause of action.
Yes, Lordship, a different cause of action, but Lordship may kindly peruse the order.
Street horn, that recovery is usually filed as a complaint case only, isn't it? Anyway, we'll
Now, Lordship,
we'll examine
Lordship,
your grievance.
Lordship, just one order, Lordship may kindly peruse. In a petition filing for recovery of the speed horn, at page 59, this is the order. Have the
59.
learned counsel for the complainant peruse the materials on record. After such hearing and perusal, I have found sufficient grounds to proceed against the accused Hamidul Islam for commission of offense punishable under section 498A IPC. And later on, Lordship, this case is, the CR case is running, holding he is accused of 498A IPC.
That we have to see then.
But Lordship's petition was filed for recovery of the speed horn, and speed horn is also recovered.
Okay. We have to see.
Yes, Lordship. So my prayer is very limited. As Lordship, this same section is running under the PRC case. Now, Lordship, this what is the meaning of running of this CR case, Lordship? So, Lordship, this case may be struck down. This is my humble prayer.
We'll examine your grievance.
Yes.
Don't
Lordship,
worry.
yes.
That is what we are for. We'll examine your grievance.
There is also interim order for not running of the CR case, Lordship.
Fine.
Interim order may be continued. He may file his reply, Lordship.
You also read up on this.
Yes,
Because
yes.
obviously,
Yes.
street horn is different.
Yes.
Whatever little I know. But on 498, there cannot be two things. That's be only one. Third, Mr. Somo and Mr. For the respondent number two, respondent number two. Two. Full stop. So the learned counsel for the respondent number two submits that this amount was directed in the context of a DV case.
Several cases are running.
In the context of CRDV case number 198 of 2022, the learned SDJM M. North Salmara Abhayapuri was pleased to issue warrant of arrest, and thereafter the petitioner was arrested and presently he is in custody. The learned counsel submits that due to the detention of the respondent, he has to take some instructions and seek some time for the same. Prayer is allowed. List the matter Any record will not need record, it is not coming.
Is pending.
Lordship,
Can we call it?
Lordship, in this present petition,
Hmm.
there is no whisper of any DB case. Here I am concerned only with two
Okay,
cases,
no problem.
TR and PR.
But we have not called for the records, I think.
Yes, Lordship may kindly call for the records,
Yes.
but Lordship, here there is no whisper of any
Issue
DB
notice.
case.
No, record has not been called. We'll call for the record of
Yes.
both the cases,
Yes, yes,
both the cases.
both CR and the PRs.
Call for the scan TCR of scan TCR of GR number,
No, Lordship, PRC case number.
PRC case number. Be careful about the number, huh? Otherwise we'll
790.
get the wrong record.
PRC case number 790 of 2022.
790 of 2022.
Yes, Lord.
Along with
CR case number 164.
the
case
TCR,
number.
scan TCR of CR number
164
164.
2002 pending before the
2022.
22, yes.
22 pending before the SDJM
That's okay.
within bracket M
Hmm.
North Salmora.
SJM and not Salman evaporate.
That's
The interim order passed by the order dated 10/12/2025, staying proceedings in CR 164/25 shall continue in the next date of
Yes,
list.
CR case is deeply obliged, Mal.
We will not. Take the date, you forgot. All of us forget. Take the date. List after 3 weeks or 4 weeks?
3 weeks.
How much time will you? 3 weeks?
3 weeks.
You suggest a date after
It
3
may be
weeks.
fixed, Lordship, otherwise
Yeah.
it will not come.
No, it will come, but
Any date from my side.
26
Obliged, man.
26 May.
Hearing BA, item number 25, 26.
Criminal petition.
এইটো নাই দেখোন তাতে।
But we have filed an IA for the correction of the cause title as per your lordship's order. But I came to know from a learned friend madam, that it has not yet come into record, madam.
Acha. Application. The criminal petition is for quashing.
Yes, yes.
Both would be connected. Primarily, it arises from the same order, lordship.
So, the cost title, shall we wait for that cost title to come?
Because otherwise, it is state of Assam.
You have to be corrected, madam, that's why.
Sure. It is Mr. Viswas, as a learned counsel, submits that.
We have filed it on 20th of March.
Oh, how come it's that the amended cost title, though filed?
Hey, for amending the cost.
Acha. Okay, an IA was already filed
On 20th of March.
on 23, 2026 itself regarding correction of the cost title, but it has not come up. So we'll direct for putting up the IA.
Yes,
Isn't
yes, have to be.
The IA may be listed along with IA number you don't have, no?
Yes, IA number is also there.
Yeah, IA number.
IA number, IA criminal 2652 of 2026.
265.
A filing number.
Number is reflected in the cause list.
Yes, 321.
321, but which is not on record.
Acha.
321. IA.
List on.
It can be on 8th.
Mhm.
It's
I will suggest on 11th.
No, I have got some problem on that.
I'll be out of station. Or it can be on 15th.
15th of May. Who pade? 15th of May.
Criminal petition of the same order.
Both the petitions are,
Same order.
there is a bail also.
The IA has been listed, however, but
It says that the record
it
is
does not come into the records. Okay.
along with one co-accused, who is the main accused. Here in this particular matter, he has already been inside jail since 503 days. He was arrested on 17/12/2024 in connection to this matter. Charge sheet has been filed since 325 days. No commencement of trial, and he's still.
Trial is not started.
Yes, no commencement of trial. In fact, production is going on. So he's being languishing in jail.
Charge should be framed.
No charge has not yet been framed. In fact, now we even do not know to what extent the investigation is taking place. That is one of the main reasons for which we have approached this Honorable High Court.
Investigation, but no, further investigation is going on.
It's already been filed. So that is number one. And then we have a very big contention here regarding the non-compliance of the Section 48. The notice under Section 48 has not been served to the relatives of the accused petitioner. Though there has been stated from the this DRI side that arrest memo was served, and in that arrest memo they have got the signature of the relative of the accused petitioner. But if we go with the details of the arrest memo, which I have not annexed because I was not having that copy, I am in that particular aspect, I would like to draw the attention of this Honorable Court to the rejection order passed by the trial court, my lord. That is page number 152, the operative part, my lord. We'll directly go to the rejection order.
152.
To how the trial court has perused and they have observed, my lord, if I'm permitted. 152 of the bail application.
I'll come. 152.
Oh yes, page number 152. That is the rejection order.
Okay.
Para 16, my lord.
Yes.
In the instant case, there is a copy of notice under Section 47 of the BNSS in the CR given to the accused person at the time of their arrest. There is also an arrest memo where brief facts of the case are written along with other particulars. The arrest memo also records that the wife of the accused was informed over phone about the arrest of the accused. This is very important. Now, here it is written, the arrest memo also records that the wife of the accused was informed over phone about the arrest of the accused. Now, we just again, just in the middle, we want to come to the objection which was filed by the DRS. The objection.
Okay.
So we want,
let us move.
in the objection.
Also, just a minute.
Yes,
let me just.
It is very important that one.
Okay. Come to page.
That is in their objection, page number 164. The objection which was filed from
Running
the
page 164.
Para 21, mine.
Yes.
My lord, here they have stated that, sir, Section 37 of the NDPS Act. Apology, my lord. It's not para 21. It should be para 17, mine. Para 17.
17.
17. Yes. That, sir, the arrest memo dated 17/12/2024 explicitly record that the arrest was made under Section 43, subsection B of the NDPS Act on the reasonable belief of involvement in offences punishable under Section 21C, Section 22C, Section 25 and 29 of the NDPS Act 1985. The arrest memo provided a detailed narrative of the events leading up to the arrest, including the seizure of the contraband goods, and thus clearly communicated the grounds of arrest. Then para number 18. That, sir, the arrest memo was duly signed by the arrested person and the arresting officer, thereby confirming that the accused was not only informed of the reason of his arrest, but he also acknowledged it voluntarily. Further, the arrestee informed his father over telephone, which is recorded in the arrest memo. Now they are saying that father. Now in here particular, the record which was perused by the honorable trial court, they have seen that it was informed to wife. So there are discrepancies in regarding the information to whom exactly the information was passed. Now, not only that information has to be passed in a manner which complies with the total compliance of the section 48. Now, if the same has been conveyed over telephone, then the notice in writing also has to be placed and it has to be served to the relative as per the mandate in Mihir Rajesh Shah as well as in Bihan Kumar and discussed in number of cases. So that is our main contention while filing this application regarding the non-compliance of section 48. And including that, we also have some other contentions regarding the prolonged incarceration, which I have already drawn Honorable High Court's attention regarding that 503 days he has already passed and 325 days have already elapsed since filing of the charge sheet. Now we have got number of citations starting with the Muhammad Muslim and all other number of authorities are there which regarding the prolonged incarceration.
Oh, that's the point.
Yes, and and at the same time, section 48, we have this particular Mihir Rajesh Shah, which I would like to place it before the honorable court.
That we can say.
Citations, Mihir Rajesh Shah.
Let us summarize the
Yes,
principles. Anyway, so record is come.
In fact, two authorities also of this honorable High Court, where it has been taken into account of the non-compliance of the mandatory requirements under section 48. So my humble submission is that, my lord, at this stage, this particular accused petitioner, if we look into the role also, he is a co-accused. He was driving the vehicle. And at the same time, in his statement under section 67, he has stated that he is an auto rickshaw driver. And he is being in friends with this particular main accused, Jamaluddin, since few months. Now, he has been driving auto rickshaw since last 6 years. So in this point of time, maybe he has come into contact with this person. And yes, maybe there was some lure of some sort of benefit if he can access in commission of the offense.
Transport something.
Yes, yes. Now, what has happened is that in the charge sheet, not an iota of transaction is there regarding this person. All transactions are with Jamaluddin. All big transactions. Now, this person, he mainly, the accusation is that for 80,000, he has committed this one. So, and
Sufficient detail.
24 to 25, during the filing of charge sheet also, they have not done it. They have even called the mother of the accused to record her statement. Then why they have cannot serve the relative that particular notice when they can examine the mother of the accused petitioner? She was also been implicated, but later on she was not charged sheeted.
The most important aspect here is a prejudice test, Your Lordship. How they have been
No,
prejudiced by
prejudice
not.
test. No, prejudice test is nothing is said in Vihan Kumar, Purkasta, and Mihir Shah that they are subject to a prejudice test.
Yes.
In my humble
only-
opinion.
Only,
And that the prejudice test comes in darshan.
Darshan,
Right.
that's
Now, of course, the prosecuting agency would like to, address darshan. I'm telling you, we have discussed this many occasions. This law is still evolving.
evolving.
Ultimately, I don't know where it will reach. Ultimately, more clarity will come on all these aspects, where you are having doubts.
Yes.
That you have a beautiful arrest memo. In all effect and substance, it conveys the grounds of arrest. Whether you will still insist on a 48 notice, this question has not yet been resolved, in my humble opinion.
That is what.
And secondly, that this test, of course, our division bench has Pranay City actually that they have referred to some old decision and saying that when there conflict between earlier has to be taken on point of view.
And
Right.
most important aspect, Your Lordship, is the satisfaction of section 37 because it's a NDPS matter, Your Lordship.
See, that is the thing. See, the thing in this kind of large scale recoveries, you would appreciate that it is so difficult to pass the test of 37. Someone being caught red-handed, how can you say he is not guilty? Prima facie. Very difficult to pass the test of 37. So the defense will definitely look for these loopholes.
Yes,
Right?
Your Lordship. At
You
the
can't
same-
blame them.
If I may just.
And
place-
if the investigating agency leaves loopholes, then definitely it will be
If I may
taken.
just place these three judgments.
Who wants to be in under trial detention?
Very
Right?
recently, Your Lordship, this 24th of April, on the Honorable Supreme Court.
I'll see. I'm saying I'll study it and properly give the order.
At first, Your Lordship, if Your Lordship takes out the case of State of Punjab versus Sukhwinder Singh Gora,
Very recent issue.
very recently, this 24th of April. There, with regards to this ground being taken, para number 9 and 10 here in Sukhwinder Singh Gora. So, just the ground taken by the petitioner here in the present case also long incarceration. And the thing is, and the ground of not letting go of section 37 also, Your Lordship. Honorable Supreme Court has specifically stated with regards to this large overhaul of cases where around 12 kgs or any large commercial quantities confiscated from the accused, Your Lordship, section 37 is mandatory, Your Lordship.
Yeah, that no doubt about that. But it has been, as you know it too well, that in Vihan Kumar, it has been said that if the court holds that in a particular case the compliance is not satisfactory, does not fulfill the law, required law, then the person has to be granted bail irrespective of statutory restrictions.
Yes.
So that's the thing. That is why in these kind of cases, whenever these technical grounds are raised, first we have to cross that bridge. Right? If you do not cross that bridge, matter ends there. You need not enter. If you can cross that bridge, then you enter into merits.
Very well. The thing is, Your Lordship, only thing.
This is a good
here-
judgment. Otherwise,
Only thing that basically I'm saying that section 48. Section 48, the main object, we must go into the intent
I
of that
appreciate your
particular
point.
section. Your
I
Lordship.
appreciate your point that when the arrest memo narrates in so much details, how can they say that they have not been informed?
They have been informed. Otherwise, how will they come to know about the arrest, Your Lordship? How will they find this bail application?
If
That
the
object has been served, Your Lordship.
if the
Once-
interpretation in the earlier cases, mainly especially Vihan Kumar and Mihir Shah, was not so much in black and white, in my opinion, then definitely that would make sense. That substantial compliance.
Yes.
But as I understand, the law is still not substantial. Ultimately, it might end up in substantial or you can think of like that. We can predict. Ultimately, the law may make a distinction for general offenses, strict compliance. For very serious offenses, substantial compliance will do. The law may reach that ultimately. But as of now, I have to study again.
Your Lordship, then Lordship may take it up day after tomorrow on Wednesday. I'll produce some judgment relating to this substantial compliance of section 48.
Rendered by Supreme Court.
Yes. Supreme Court on this very issue.
But if it's quorum is same, then we'll be confronted with the same problem. If quorum has to be higher. If it's a
Higher.
3-judge bench, then already the matter would be settled.
Lordship, now my learned friend,
Just
he has
that-
stated that how come they have come to know and why they have not even raised this contention earlier. Now, in my same, I can take it up with my friend that when the person they have come, then why they have not been served with that notice? What made the DRI so incomparable that they are not able to serve the notice to them? So this is a clear-cut case, my lord, at this point of time that there has been a violation. And regarding that
Point
insurance,
going back that why it was not noticed, it was not served.
Yes.
So now we have to only decide whether
Absolutely.
the arrest memo can fill in for 48.
My lord may pass an order in this, my lord. Whether it is rejected or it is allowed, that is a different case. But my lord is, after being satisfied, my lord should pass an order.
You want
Because
to,
already it has been late, my lord, since we have filed this bail application on February. Now it has come to, now he has been already inside jail.
Your Lordship, if with regards to long incarceration also, I'll just mention the dates. Your Lordship, this bail application they had filed before the lower court on 28/8/2025. And therein, after this bail application was rejected on 8/1/2026. In the meantime, they filed one Zimma application, which was filed on 1/12/2025. So the lower court was actually busy with all these applications being filed by the petitioner. Now,
My lord,
because
that is a
of
different
non-disposal of those cases,
Already,
Your Lordship,
Zimma has been
perhaps the
disposed
charge
of.
has not been framed. That is a different issue altogether. But at the same time, Your Lordship, it is not that case. The petitioner also did not appear on many occasions before lower court. It is there in the order sheet also. Now, I'm not talking on that particular
Petitioner is
aspect.
inside
And
jail,
it
my
is
lord.
not
He is
that-
always been
it is not
produced
that
to
they have
DC.
actually been caught
Then how he cannot appear
red-handed
before
with
the court?
The judge. They have been caught red-handed with 12 cases
Yes,
of meth
absolutely.
tablets, Your Lordship.
We are not
It's a
into that
serious offense.
matter. We are not into the merit of the case. That has to be taken during
Anyway,
the trial stage.
So should we, I'll
Tomorrow,
reserve it or
Lordship.
you want another date?
One date, Your Lordship, tomorrow,
My lord,
after tomorrow.
we have already,
Yeah.
After tomorrow.
Yes.
my lord, my
2 days, Your Lordship.
obliging.
If I'm not able to produce any judgment on this aspect, then Your Lordship may
But
pass order.
we are sure about this, that this is an evolving law. This is an evolving.
Your
And the
Lordship,
sooner all the areas, all these areas where there is some confusion, the sooner authoritative pronouncement is made,
Yes.
by either some full bench of High Court or Supreme Court, preferably, that is better for defense as well as prosecution. And clearer the law, the less will be the mistakes.
every day, Your Lordship, the law is evolving.
Because
Just as I produced
in a
it
way,
yesterday.
if you say that substantial compliance, will do, then that would looking at it from a negative side. If you allow substantial compliance, then it will also provide scope for more mistakes by IO. If it is strict, suppose clear interpretation, then the IO will know that if I don't give, gone. If I have to give. So he will be more careful about
Absolutely.
interpretation. Right?
That is
The addresses learned counsels for this thing. I'll keep it as part of. But you're representing NC,
He's DRI.
DRI, special public prosecutor, standing
Senior
counsel,
standing counsel.
senior standing counsel, DRI. Six some time for some further arguments as well as citing some decisions. The prayer is allowed. List the matter on day after tomorrow.
Obliged.
Day after tomorrow.
Highly obliged, Lord.
28.
Compilation के लिए आता बेलेक्टेड हो এখন board separately for you. Just a minute.
But item number 38, my lord, that may kindly be time being, my lord. My learned colleague, he has gone through. Which
Just a minute.
28.
আগৰটো কিমান আছিল?
28.
Manoji, আগৰটো কিমান আছিল? Yes, item 28. What is your submission?
28 also, my lord. Mr. Goswami has gone through that, my lord. He's
Okay.
coming, my lord.
After some time.
Yes, my lord. After
Sorry, you are appearing for informant.
Yes.
28 and
28, my lord, he has already
he's
come.
come. He's come running.
28.
We can take it up after some time if you need some. After some time.
I'm ready.
You're ready.
Lordship, in this case, Lordship, the accused petitioner 63 days is behind the bar, Lordship. An allegation is cease of POCSO. In the FIR page 11, Lordship.
This is already charge sheeted.
Lordship, what happened in this case, Lordship? And Izahar filed on Lordship 1/3/2026, Lordship. And as per birth certificate of the victim, he was 19 years old, Lordship, when he lost the affair, Lordship. And after 2 years, Lordship, there happened love affairs. And before this filing, before this lost the affairs, Lordship, before 6 months, they solemnized their social marriage, Lordship. And after pregnancy, 2 months, Lordship, they as per government order, Lordship, registered her name in the Lordship PAC for better treatment, Lordship. Husband of the Lordship victim.
Okay. They are married, got married?
Yes, Lordship. And as per Lordship, I am not annex this, but collect
Instance,
all the documents. Lordship.
Informant counsel is also here, so
Yes, ma'am.
we can get a clear
Yes.
feedback on that, your instruction. Yes.
Yes, ma'am. Lordship, kindly take up the this here, ma'am. The Lordship will find from the 183 statement and also the search sheet.
He was arrested on?
Lordship, 2/3/2026.
2026. Yes.
Kindly see the, my lord, the what has been stated in the, my lord, FIR, my lord. In the investigation, all has come out to be true, my lord. Was a minor. She was pregnant at that time, my lord. And the medical report also support that, my lord. Kindly see the medical report and also the 183 statement, my lord. I have flag mark, my lord. First, Lordship, may kindly see the medical part, my lord.
What's the medical part?
And last, in the last page opinion, my lord, Lordship will find the was pregnant.
7 weeks.
Apparently she was minor.
So it's a clear case of POCSO as of now, my lord. And now, well, my victim
Trial has not started.
Trial has started, my lord. It is the stage of appearance, but
Victim is, oh,
2526.
evidence has not started.
No, no.
2526 is the next date fixed, man. And I pray that let the victim statement may be recorded first, my lord. Thereafter, Lordship may consider. Type of cases, my victim statement is very much important as a lawsuits. Up now, my the evidences are against the petitioner. You also see the statement of the accused, madam.
Yeah, that's true. Yes, sir.
Yes, but I endorse my view with my learned friend, but in submission, it is he or she is minor. And with the promise of these things has been done. If they got married, marriage matter could have been different. He is refusing to marry.
So let
And Lordship, 25/10/2025, Lordship, Solomon their social marriage, Lordship. I submit this, Lordship. And after pregnancy,
the,
her name
you don't have that instruction.
No marriage has taken place, my lord. As per my land, what my submitted land,
Maybe-
let him appear before the court, my lord. He's even let the statement of the girl be recorded. And if anything else, the marriage is there, it will come in the evidence. Then
Okay.
trial court can consider the matter.
And Lordship, kindly consider Lordship, while a victim statement is very much
Yes,
important.
first her statement be recorded.
Kindly recorded that I am ready to conjugate life with the victim, Lordship, and social marriage already solemnized.
Yeah, but
And after
here,
pregnancy, Lordship, they are
Learned counsel for the informant, is denying that actually. Anyway, I think
yes, Lordship.
it will be, we have no option but to take that view only. In these matters, isn't it? M.A. Mondal, learned counsel, MP Goswami, SCB, learned counsel for the petitioner. Invoking 483 BNS, the learned, the petitioner is seeking regular bail in connection with Gauripur PS case number 63 of 26 under section 6 of the POCSO Act, which after completion of investigation was registered as special. What is the special case name? Hello, was registered as so and so case and pending before. It is at Dhubri, learned special judge Dhubri. The petitioner was arrested on 2/3/2026 after the registration of the case, alleging commission of penetrative sexual assault upon the victim stated to be a minor, comma, and leading to her pregnancy as well. The scan TCR has been received. Mr. Goswami, learned additional PP, submits that the girl, the victim girl has not been examined part of the trial, and therefore he objects to the grant of bail at this stage. The Biswas learned counsel for the informant has also supported supporting his affidavit in opposition. Concurs with the submission of the prosecution that the victim may be examined. The learned counsel for the petitioner submits that in the meantime, the petitioner and the girl have contracted social marriage, semicolon, which however is denied by the learned counsel for the petition. Learned counsel for the respond number 2, informant. Peruse the statement of the girl recorded for learned JMFC and noted the implications therein against the present petition. The materials prima facie indicate her to be a minor at the time of the alleged incident. Finding force in the contentions of the prosecution and the informant side, the bail petition stands rejected at this stage. Let it proceed.
Deeply obliged.
Come to it.
32.
May I please your lordship? Lordship, matter kindly adjourn this today
Today? John, today.
because my senior left the court due to personal difficulties.
Okay. The scan TCR has been received. Learned counsel for the, your good name, please.
Sita Lukdar.
Sita Lugdal for the petitioner. Seeks an adjournment today. The leading counsel is having some personal difficulty. When should we fix it? This week on?
Next week.
It's on 12/5. 12.
33.
Asim may kindly take it up after some time. The professor is have gone through and he's coming.
2.
But
He'll
anytime
come, my-
as per your lordship's convenience.
Come.
34.
So this is a POXO case, my lord, under section 8 of the POXO Act, my lord. And the petitioner has completed 40 days.
But immediately they should produce.
And in Subhas Kumar, Lordship, Directorate of Enforcement, the Supreme Court has clearly stated that the Honorable Supreme Court has clearly stated there is a violation of Article 22, Lordship, on page 3, Lordship, where it has been clarified the time of the physical custody will be considered. On page 3, Lordship, the whole para, Lordship.
I am reading that one. Para 6.
Para 6, Lordship.
Yeah, what is the progress of investigation? This is intermediate quantity also.
2 cases.
As per last note, my lord, FSL is not been received till date.
That will take some time.
Yes.
Otherwise, Lordship, it is a case of illegal detention and violation of Article 22, Lordship. Where the arrest and vitiated.
If they do not keep these details in mind, there will be many technical failures
Yes.
of arrest in serious matters. Merit is different.
The view has been taken by the coordinate bench also. To coordinate bench order also. 41.
Arrest procedures take time. This is one of the submissions of the prosecution. They definitely take time, no doubt. Or the arrest procedure has to be done immediately then. With the slight small suspicion, moment there is suspicion, you arrest the person then. That has to be done. Otherwise, the moment, by the time they complete their formalities, 24 hours will be over.
Yes, my lord. My lord, in the night, my lord, he was after he was.
Then the accused will have to accept that on suspicion he will be arrested. If the 24 hour has to be followed.
The night, my lord, he was apprehended.
Then the accused will say that without following procedure, he has been arrested.
Yes, that will be.
But they have to be careful. This is the law. You have to be careful.
That time is very
very clear. That if the law has to, is that it has to be counted from the date of time mentioned in the arrest memo, then it's different. But if it is from the period of from the detention, then they have to know that it has to be counted from there. Actually, this is the period. The time is calculated from the time of detention, because that is wise. Because otherwise, someone may be detained for 3 days. and then shown arrest, during
it
that
can
period
be.
of detention, there's risk of all kinds of things.
Yes.
But it's always better that
Yes.
it's the detention should be from the date of detention.
Yes, ma'am. From the date of time of apprehension.
Anyway,
Here in this case, my lord, he was apprehended on the night, my lord.
yes, no, there are a lot of practical difficulties. I
After that, my
understand.
lord, after that, the seizure, for the seizure procedure, my lord, it will take some time because seizure witnesses.
Yes,
have to
yes,
be
that is
called.
there. That is
And
there.
after that, on the next day, he was arrested, my lord.
That is there. That is
So
there.
there is no any just clear violation of just only the procedure of one day, my lord, because the next day he was arrested. After the seizure.
Was shown to be arrested of 26.
Have they mentioned that he was detained at so and so? That they will not mention. Have they mentioned?
Yes, they have mentioned that
Where?
in the FIR.
19.5.
The FIR dated 24/3/26. Lordship,
Yeah.
from the third para Lordship FIR, during drive at around 7:20, which is 19:20 hours, we noticed one male person was coming hurriedly from platform number 1, Gauhati East side, carrying with one sky blue backpack in a suspicious manner. On the ground suspicion, the person was
Detention only.
The person was detained.
He was interrogated. No, this will be detention only.
That physical custody was taken then and there, Lordship.
Anyway.
That is what been discussed, Lordship.
Anyway, so any case, investigation is complete. In this case, there's not so much of a problem because it's an intermediate quantity. But in commercial quantity, it poses a lot of serious problem. It's not easy for investigating agency, but still they have to follow. Otherwise, that is the law. They have to have that, that diligence.
Because after apprehension, my lord, he was interrogated.
Anyway,
everything is done.
whatever it is, it has to be done.
Yes,
They have to be that smart. There's no other option. Heard Mr. D. Mary, Learned Counsel, and MP Goswami, Learned Petition, additional PIP. Invoking 483 BNSS, the petitioner is seeking regular bail in connection with Gauhati GRPS case number 63 of 26 under so and so. He was arrested on 25/3/2026. The FIR was lodged on 25/3/2026. The gist of the allegations was that surveillance was conducted at Kamakya railway station against crime and antisocial activities, and on 24/3/2026, and at 7:20 p.m. One male person was found coming in a suspicious manner, and he was checked and revealed his name as Vivek Hussain from West Bengal. Full stop. It is alleged that he was asked to open the bag which he was carrying, and therein 2 packets were found of suspected ganza, which was weighed and found to be 2.223 kgs. Some other materials were also seized by seizure memo. The accused was brought to the RPF post. The arrest memo indicates the date of arrest as 25/3/2026 at 9 p.m. Full stop. The case diary has been received, and the learned additional PP submits that the forensic report is awaited.
The list says, my lord, it is the contraband was seized from this.
It is submitted that as far the seizure list, contraband was seized from the possession of the present petitioner. One of the contentions of the learned counsel for the petitioner is that he was detained as revealed by the FIR. As revealed by the FIR, he was detained at 7:20 p.m. on 24/3/26 and produced on, when he was produced?
26/3/26.
Order is there.
Forwarding is
He
there.
was arrested on, my lord.
Forwarding is there.
And produced before the magistrate on 26/3 as for the forwarding report, which is beyond the period of 24 hours. and thereby violative of the constitutional provisions, comma, making the further detention untenable. Full stop. However, as already stated in the arrest memo, in the said forwarding, the date and time of arrest is mentioned as 25/3/26 at 9 p.m. Where is the forwarding? This is the forwarding.
Page 23.
In support of his contention, the learned counsel for the petitioner has referred to the decision of Directorate of so and so and two decisions of coordinate bench in so and so and so and so, which has reference to the decision in Subhash Sharma, Supra. The relevant paragraph of Subhash Sharma, Supra is reproduced here in below, para 6 to 31. In the said decision, in the facts of the case, the petitioner, the accused was detained at the IGI airport at 11 hours on 5/3/2022. But he was shown arrested at 1:15 a.m. on 6/3/2022 and produced on 6/3/22 at 1:15 p.m.
PM. Produced.
The Honorable Apex Court, in the facts of that case, held the production to be beyond the period of 24 hours, as he was not produced by 11 a.m. on 5/3/2000. Hours, 11 p.m. that is. He was in this case, he was detained at 11 hours. That means 11 a.m.
Yes, sir.
11 a.m., right? But he should be produced. No, this is an error, I think. 11 a.m. on 6th March, it should be. No, it should be 6th March in the order.
I think
It should have been 6th March. He was produced at 1:15 p.m. on 6th March.
Maybe typological.
Held to be beyond the period of 24 hours, counting the said period from his detention at 11 hours on 5/3/2022. The learned counsel for the petitioner seeks the benefit of a similar seeks benefit of a similar application in the instant case, and submits that in the decisions of this court rendered by the coordinate bench also, Subhash Sharma was referred to, and such benefit was given to the accused persons in that case. I've given my consideration to the matter. The investigation is progressed and pending only for the FSL report. Moreover, there appears to be some infirmity in the arrest procedure as well. Full stop. In the entire facts and circumstances, and also considering the length of detention, the accused is hereby allowed to go on bail of ₹50,000 with one surety of the life amount to the satisfaction of the concerned learned court. Which court will it be?
Special Judge Kamrup Metro.
Kamrup Metro, and subject to the condition that he shall cooperate with the remaining investigation, shall not hamper or temper evidence, shall not commit any illegal activities or offences, including any offences prohibited under the NDPS Act. Violation will till cancellation of the return back the case time is possible.
Record my objection regarding the merit part.
The learned additional PP objects submits that he, at this stage, he has objection to grant of bail. And that on the date of arrest, reflected in the arrest memo, there is no violation of the constitutional provisions vis-a-vis production before the magistrate. Vis-a-vis first production before the magistrate.
33. Wait, please, Your Lordship.
Okay.
So the issue here involved would be just like the earlier item, my lord, which your lordship heard. Here
one?
also this person was not produced within 24 hours, my lord.
Hmm.
The case involves, my lord, recovery of 23 kgs of ganja, my lord. And your lordship will kindly see the FIR, which your lordship will find at page 13.
This commercial, they have given 27A also.
Yes, my lord. No, my lord, 21, 21, B2C and 29, my lord. Charges have been framed under these sections.
21, B, 2, C.
2C, capital C,
And
and
29.
29.
27 has been dropped.
Drop, my lord. Your lordship will find the FIR at page 13, my lord. This on 23rd of August. my lord.
That was commercial intermediate
intermediate
quantity.
quantity.
So I did not go so deep into the issue, but if it's a commercial quantity,
Commercial.
then 37 comes. All these technical issues have to be gone into more deep.
My lord. That is
Page
page 13, my lord.
13.
13. So the interception was on, my lord, 23rd of August. Your lordship will see that this is to inform you that based on specific information received on dated 23/8/2025 at around 4:34 p.m. by reliable source regarding dealing of suspected NDPS items which were coming from Silchar side towards Lamding. Accordingly, DSP so-and-so is informed by OC Lamding PS and GD entry by GD entry number so-and-so dated 23/8/2025. And SI Onkur Kakoti formed a team for do the needful against the suspects, NDPS peddlers, and accordingly SI Onkur Kakoti along with UBC Ritu Bora and 2 numbers of ABP and staff of so-and-so proceeded with operation on government vehicle. So, my lord, on 23/8, the information is received at 4:34 p.m. So, my lord, records have also come. The actual recovery and the actual seizure was done on 23/8/2025 at around 8 p.m. my lord.
Okay.
So, at 8 p.m., these persons were intercepted. At 8 p.m., this contraband was seized. Now, your lordship will kindly come to the next page, my lord.
At 8 p.m.
8 p.m. Even if we assume that, my lord, at 8 p.m. there is no apprehension, but on the next page, second last paragraph, my lord, last line, my lord.
Okay.
On dated 24/8/2025 at about 1:30 a.m.
Okay.
So 23rd night, this continues at 1:30 a.m. I, along with the 4 numbers of apprehended accused persons. So by that, at 1 p.m., even if we take this time, at 1:30 a.m., I have already been intercepted. Sorry, I have already been apprehended by the police and I am in their custody.
1:30 a.m.
1:30 a.m. on 24th.
Even if we ignore the other part.
Other part,
previous part.
even if we go by this part of the FIR. Now, my lordship will kindly come to page 17. 16, that's the notice under section 47, my lord. Relevant portion at page 17. Page 17, if your lordship has. Particulars of offense, my lord, on the top. Number D, my lord. Date, time, and place of arrest. Now, here they have shown that I have been formally arrested on 24/8/25 at 1 p.m. So I was apprehended at 1 a.m. in the morning, but formally shown to be arrested at 1 p.m. on 24th.
So we have to calculate from 1:30 a.m.
1:30 a.m., my lord. Now, your lordship will kindly see the next page, page 18.
Production.
Product for forwarding, my lord. Now, forwarding, that it is dated 24/8. So, in the forwarding, they have written 24/8, my lord. But your lordship will see the signature of the magistrate on the top part itself, my lord.
25.
25. And your lordship will now kindly come to page number 26. This is the remand order, my lord. 25th, my lord. So at 24th morning at night 1 a.m. these persons are apprehended, taken into custody to the police station.
They have to be produced actually
on 20,
during the daytime.
They had the entire day.
Till evening.
Till evening they had the entire day.
Produced. But they were
not
probably produced on 25th.
25th, my lord. So this 24-hour period, my lord, goes, my lord. On
It
the,
seems so.
my lord, my learned friend in the earlier matter had already argued and placed some judgments. I have, your lordship will find 2 judgments in the record, my lord. In the record itself, my lord.
I'll need some there because this I think I will reserve because I need to study this point also.
It is there in that, my lord, main record, my lord, in the bottom part, my lord, 2 judgments, my lord. Last part.
Oh, this, yeah. Subhash Sharma is here.
Subhash Sharma, your lordship has already seen, my lord. Just, my lord, I'm just.
So detention, let us refresh.
Yes.
You know, in terms of constitutional,
Yes.
constitution says date of arrest.
Date of arrest.
But it has been interpreted to mean the time and date of detention.
He is taken
In
into custody.
DK Basu.
DK Basu custody. And here, my lord, there's another judgment. I'll rely on that. First, your lordship will kindly see the Subhash Sharma, my lord. From para 4, my lord. Your lordship, I think, has already gone through Subhash Sharma.
I'll see it again.
So
He was detained at Indira Gandhi Airport
Yes,
by the immigration.
Yes, on 4/3/2022, he was taken into custody at 6 p.m. my lord.
Which we are reading?
Para 4, my lord.
From the judgment.
From the judgment, my lord.
Para 4.
Para 4, my lord.
The documents, the High Court has recorded findings.
Yes, ma'am. From the documents available in the case diary and the aforesaid order, it is crystal clear that the applicant was detained and taken into custody at 1800 hours, that is 6 p.m. on 4/3/2022 at IGI Airport, New Delhi, when the Bureau of Immigration executed the LOC issued against the applicant and held him in custody on behalf of ED. It is also not in dispute that ED took physical custody of the applicant from the Bureau of Immigration at 1100 hours, 11 a.m. on 5/3/2022 and brought him to Raipur, where the ED in afternoon of 6/3/2022 before the remand court. Here, in fact, there are 2 agencies. Bureau of Immigration catches him, then hands him over to the ED, and yet the Honorable Supreme Court says that it is from the period he is taken into custody, that 24-hour period has to be reckoned, my lord. The para 6 is important, my lord. Admittedly, the LOC was issued at the instance of the Appellate Directorate of Enforcement. By executing the LOC, the Bureau of Immigration detained the respondent at IGI Airport from 4th of March 2022 on behalf of the appellant. The finding of fact recorded in paragraph 10 is that undisputedly the physical custody of the respondent was taken over by the appellant from the Bureau of Immigration at 1100 hours on 5th of March 2022. Thereafter, at 1:15 hours of 6th of March 2022, an arrest memo was prepared by ED at Raipur. He was produced before the court at 3 p.m. on 6th of March 2024. That should be perhaps 22. That's a typographical error. The perusal of the arrest order shows that the typed order was kept ready. The date and time of arrest were kept blank, which appear to have been filled in by hand. Admittedly, the respondent was not produced before the nearest learned magistrate within 24 hours from 11 a.m. on 5th of March 2022. Therefore, the arrest of the respondent is rendered completely illegal as a result of the violation of Clause 2 of Article 22 of the Constitution of India. Thus, the continuation of the respondent in custody without producing him before the nearest magistrate within the stipulated time of 24 hours is completely illegal, and it infringes fundamental rights under Clause 2 of Article 22 of the Constitution of India. Therefore, his arrest gets vitiated on completion of 24 hours in custody. Since there is a violation of Article 22(2) of the Constitution, even his fundamental right to liberty guaranteed under Article 21 has been violated. Well, even in this case, my lord, your lordship will see that he was taken into custody, even if we ignore the period where the seizure and apprehension was done. Admittedly, as per the FIR, he was taken into custody on 24th at 1 a.m. So from 24th 1 a.m. till 25th 1 a.m., that 24-hour period, that window was available to the police, my lord. Now that was not done, and he was produced on the day of 25th, my lord. So that 24.
So it was mentioned as 24 in the forwarding.
Forwarding it was, but orders are very clear.
Forwarding must have been prepared
earlier, my lord.
But it was produced and then passed on the same day.
On the 25th. Now another judgment your lordship will kindly see.
This will be a leading case.
Yes, ma'am.
Though it's not very long. This will emerge as a very important case, it seems.
No,
it's rendered in 2026.
25, my lord.
2025. It appeared to me that the in citation is of 26. Anyway. The INSC citation.
That is of 26. The SCC is of 25, my lord. Now the other judgment where, my lord, this dichotomy of custody and arrest has been properly explained by the Supreme Court, that your lordship will find State of Haryana versus Dinesh Kumar.
Service law.
2008, 3 SCC 2022, my lord.
But service law, but this has been discussed.
No, the issue of arrest and custody has been discussed, my lord. Your Lordship will kindly come to paragraph 16.
Must have been some suspension method.
Yes, my lord.
Era 16.
It starts from paragraph 14, my lord. I will start from 14, my lord. Here also the same issue came up, my lord. Paragraph 14, if I may read, my lord. We are concerned with subsections 1 and 2 of section 46 of the code, from which this much is clear that in order to make an arrest, the police officer or other person making the same shall actually touch or confine the body of the person to be arrested unless there be submission to the custody by word or action. Similarly, the expression custody also has not been defined in the code. The question as to what would constitute arrest and custody has been the subject matter of decisions of different high courts, which have been referred to and relied upon by Mr. Patwalia, appearing for Dinesh Kumar, the respondent in the first of the two appeals. This court also has had the occasion to consider the same question in a few cases, which we will refer to shortly. Reliance was also placed on the dictionary meaning of the two expressions, which will also be relevant to our discussion. Mr. Anup Chaudhary, learned senior advocate who appeared for the state of Haryana, in both the appeals submitted that when the respondent in the first appeal and the appellants in the second appeal had appeared before the magistrate and prayed for bail, it must be understood that they had surrendered to the custody of the court, as otherwise the provisions of section 413 of the code would not have had application. Mr. Chaudhary also submitted that it did not matter as to whether the accused persons had been arrested and detained in custody by the police or not. The very fact that they voluntarily appeared before the magistrate and paid for bail amounted to arrest of their movements, since thereafter they were confined to the courtroom and were no longer free to leave the court premises of their own choice. Mr. Chaudhary submitted that the ordinary dictionary meaning of arrest is to legally restrain a person's movements for the purpose of detaining a person in custody by authority of law. He submitted that in Dinesh Kumar's writ petition, the High Court had erred in coming to a finding that he had never been arrested since he had voluntarily appeared before the magistrate and had been granted bail immediately. Opposing Mr. Chaudhary's submission, Mr. Patwalia, relying on the various decisions of the different high courts and in particularly a full bench of the Madras High Court in so-and-so case, submitted that although technically the appearance of the accused before the magistrate might amount to surrender to judicial custody, in actuality no attempt had been made by anyone to restrict the movements of the accused, which may have led him to believe that he had never been arrested. It is on a layman's understanding of the principle of arrest and custody that prompted the respondent in the first of the two appeals and the appellants in the second appeal to mention in column so-and-so that they had never been arrested in connection with any criminal offense. Para 20, my lord, I am skipping 20 and 21, I am coming, my lord. In coming to the aforesaid conclusion.
Just a minute. Let us just spend some time on the last part of para 20. It is in the afforded circumstances, the full bench.
My lord.
Can you read that?
My lord.
Full bench came to the conclusion that person taken by customs officer.
Customs officer, my lord.
For purpose of inquiry cannot be said to have come into custody.
My lord.
And detention cannot be deemed to have been arrested from the moment he was taken into custody.
Yes, but here this part, a custody may amount to arrest in certain cases, but not in all cases. It is in the aforesaid circumstances that the full bench came to a conclusion that the person who is taken by the custom officer, either for the purpose of inquiry or interrogation or investigation, cannot be held to have come into the custody and detention of the customs officer, and he cannot be deemed to have been arrested from the moment he was taken into custody. In coming to the aforesaid, this is the conclusion of the Punjab and Haryana High Court, my lord. And Madras High Court. In coming to the aforesaid conclusion, the full bench had occasion to consider in detail the meaning
of the conclusion of the High Court.
High Court's, my lord. In coming to the aforesaid conclusion, the full bench had occasion to consider in detail the meaning of the expression arrest. Reference was made to the definition of arrest in various legal dictionaries and Halsbury's Laws of England and also Corpus Juris Secundum. In para 16 of the judgment, it was observed as follows. From the various definitions that we have extracted above, it is clear that the word arrest, when used in its ordinary or natural sense, means the apprehension or restraint or the deprivation of one's personal liberty. The question whether the person is under arrest or not depends not on the legality of the arrest, but on whether he has been deprived of his personal liberty to go where he pleases. When used in the legal sense in the procedure connected with criminal offences, an arrest consists in taking into custody of another person under authority empowered by law for the purpose of holding or detaining him to answer a criminal charge or of preventing the commission of a criminal offence. The essential elements to constitute an arrest in the above sense are that there must be an intent to arrest under the authority, accompanied by a seizure or detention of the person in the manner known to law, which is so understood by the person arrested. In this connection, a debatable question that arises for our consideration is whether the mere taking into custody of a person by an authority empowered to arrest would amount to arrest of the person, and whether the terms arrest and custody are synonymous. Faced with the decision of this court in Niranjan Singh versus so-and-so, the full bench distinguished the same on made by this court, or on an observation made by this court, that equivocatory quibbling that the arrests have taken into a man into informal custody but have not arrested him, have detained him in interrogation but have not taken him into formal custody, where this particular lordship will notice, where unfair evasion of the straightforwardness of the law. This court went on to observe further that there was no necessity of dilating on the shady facet, as the court was satisfied that the accused had physically submitted before the session judge, giving rise to the jurisdiction to grant bail. Taking refuge in the said observation, the full bench observed that the decision rendered by this court could not be availed of by the learned counsel in support of his contention that the mere taking of a person into custody would amount to arrest. The full bench observed that mere summoning of a person during an inquiry under the Customs Act did not amount to arrest so as to attract the provisions of Article 22(2) of the Constitution of India, and the stand taken by the persons arrested under the Customs Act should be produced before a magistrate without unnecessary delay from the moment the arrest is effected and had to fail. So that is the view which was taken by the full bench member. Now the Honorable High Court, Supreme Court says that we are unable to appreciate the views of the full bench of the Madras High Court and reiterate the decision of this court in Niranjan Singh. So in Niranjan Singh, Supreme Court said that, my lord, these aspects cannot be diluted, my lord, and this will come to be an unfair evasion. So Honorable Supreme Court says that the view of the full court of the Madras High Court was not correct and reiterates Niranjan Singh, my lord. In our view, the law relating to the concept of arrest or custody has been correctly stated in Niranjan Singh's case. Para 7, 8 and the relevant portion of para 9 of the decision in the said case state as follows. When a person is in custody within the meaning of section, when is a person in custody within the meaning of section 439 CRPC? When he is in duress, either because he is held by the investigating agency or other police or allied authority, or is under the control of the court having been remanded by judicial order, or having offered himself to the court's jurisdiction and submitted to its orders by physical presence. Here, my lord, we are concerned with the first part, my lord. In duress because he is held by the investigating agency. No lexical dexterity nor precedential profusion is needed to come to the realistic conclusion that he who is under the control of the court or is in the physical hold of an officer with coercive power is in custody for the purpose of section 439. This word is of elastic semantics, but its core meaning is that the law has taken control of the person. The equivocatory quibblings and the hide and seek niceties sometimes heard in court that the police have taken a man into informal custody but not arrested him, have detained him for interrogation but not taken him into formal custody, and other like terminologies, dubities, are unfair evasions of the straightforwardness of the law. We need not dilate on this shady facet here, because we are satisfied that the accused did physically submit before the sessions judge and the jurisdiction to grant bail thus arose. Custody in the context of 439 is physical control or at least physical presence of the accused in court coupled with submission to the jurisdiction and orders of the court. He can be in custody not merely when the police arrest him, produce him before a magistrate and gets a remand to judicial or other custody. He can be stated to be in judicial custody when he surrenders before the court and submits to his discretion. I mean, this case clearly examines these aspects of custody and arrest. So Honorable Supreme Court reiterates this decision of Niranjan Singh and saying that as long as the person is held by the investigating agency or other police, my lord, he will be deemed to have been in custody, my lord, and for the purpose. So this cannot be diluted by saying that this was not a formal arrest. So my lord, Dinesh Kumar read with Subhash Sharma, my lord, at least there is no dispute, my lord, that the moment a person is taken into custody by the police, he is apprehended and detained in the police station. There are period of 24 hours, my lord, the window that starts, my lord. It has to be reckoned from that time, my lord. So that has here clearly been violated, my lord.
Yes, Customs Act, it is held to be different.
Different, my lord.
Different. But in case of normal criminal law,
My lord.
it has that distinction has not been applied.
Not been made. So this is, my lord, one aspect of the matter. If your lordship is satisfied on this, there's another aspect which I would not raise, my lord, because it would become superfluous if the lordship agrees on this point. Because there's also the issue of the 48 notice, my lord.
48, no, you can say though that is also technical. That is also a technical aspect. The law can provide,
Yes.
the law can provide something, concept of pre-arrest detention. Suppose the law can, by statute, it can be provided. Now, like we have preliminary inquiry, something prior to investigation. But under the law as it exists today, there is no concept of any such, the detention before arrest. We have only two kinds of detention now: arrest, detention, and arrest and preventive detention. And of course, conviction is different. Arrest and preventive detention. So there's not really there's nothing in our law, as I understand, if I've understood correctly, that there is anything called pre-arrest detention. In fact, this expression appeals to me that the evading the straightforwardness of law. There can be risk. A person can be at he can be detained, subjected to interrogation, say 4 or 5 days, and then put under arrest. So it can lead to some risks. If you bring a law that there is, in certain cases like in customs, this is discussed, that there can be pre-arrest detention also. Then for that, you have to make your own legal form modalities. The law has to prescribe the checks and balances as well.
Yes, ma'am.
As it exists now, we have only arrest. So sometimes that is a problem for the law enforcing agency, but that is the law. Anyway, 48 notice I'll hear, then I'll go to Mr. Prasan.
Page 44, my lord.
Before.
This is my bail petition, my lord. Bail order, my lord. Earlier rejected, my lord. So your lordship will see para 1, 2, 3, 4, 5. Para 5, my lord, I raise the plea. The learned counsel for the accused persons have submitted that they've taken a specific plea in the bail petition that the notice under section 48 of BNS were not served upon the friends, relatives, or family members of the accused persons, and as such, they are entitled to bail. On the other hand, learned public prosecutor Hojai has submitted that notices to the family members were sent by WT message. I have gone through the case record and I have found that WT messages were sent to the family members of the accused persons, but it is not clear whether the notices were served upon the family members or not.
So he was directed to ascertain.
So learned public prosecutor was directed to ascertain this aspect. Now your lordship will see the bail rejection order at page 51. Sorry, it starts at page.
It should have an endorsement in the case diary. Otherwise, how will you know? Right?
Yes. So, my lord, this
51.
It starts at 46, relevant portion at page 51, my lord.
Okay.
Last paragraph. Seen the bail petition under so and so for granting bail to so and so in connection with this. The accused persons are in custody with so and so involved offences and so. My lord, this aspect which the learned session judge, special judge himself had made an inquiry from the public prosecutor that whether there is any material to show that this was served. Now, this was not taken care of, my lord. This aspect was not examined, my lord. Only on section 37 part, my lord, no discussion on this aspect. Rigors of 37 were applied and, my lord, bail was rejected. That part, obviously, my lord, 37 would come in. So this part has also not been examined, my lord.
Okay. Well, being an officer of the court, I have to go by the whatever in the record, my lord.
Of course.
No,
some things are very difficult for the prosecution nowadays. But as I said, these offences, say passing the test of 37, when large quantity of this kind of drugs are purportedly seized, it's so difficult for the defense. So they will obviously defense will see if there is any escape route through these loopholes. These are also constitutional rights.
In any usual case, my lord, if someone is called to the police station and allowed to sit for 2 to 3 hours, subsequent not arrested, it may be preliminary investigation stage. But in this particular case, my lord, 23 kg of suspected ganja that was seized. And of course, my lord, yes, maybe on 23rd at 8 p.m. But in the FIR itself, my lord, it shows that, my lord, 1 p.m. apprehended persons along with that ganja, my lord, at 1 p.m. 24/8. And the whole day, my lord, they are wasting the day, my lord. 24th, they have to produce. My lord,
they also have their difficulties, many formalities.
I would like to point out, my lord, that my lord, arrest memo, I have flag mark in the record. Arrest memo shows, my lord, 1 p.m. on 24th. In the word used in, my lord, the FIR itself, my lord, that apprehended person, my lord. And that is, of course, at 1:30 a.m.
Fairly and honestly, they have stated apprehension at so and so. That's okay.
And
but in the arrest memo, they have written like that. That means he was formally arrested at that time.
Arrest memo at 1 p.m.
Formally, he was arrested.
Formally arrested. And though it is forwarded, dated is in the forwarding report is 24. But of course, the magistrate that is at 25th, and order of the magistrate also of 25th.
And 48 aspect.
Yeah,
Could you
that,
no, find the notice?
matlab
47 is there.
47 is there.
Yeah, the
So
47.
that-
All they have to do is reproduce the 47 notice and
They
mark
sent
it.
it by WT message,
Uh.
but they did not ascertain whether this notice was served.
These things they have to take care. These things at least they should take care. 47 notice is very detailed, very detailed. 47.
Every police station there is should be a nodal officer as per 48 BNSS, my lord. And it can be served, my lord. And one case I have seen, my lord, it was sent through WhatsApp message and the my screenshot was in the case diary and mil gaya hai. That could my lord rejected. My lord, the screenshot shows that my lord, the whole notice, he got the notice, my lord. And if nothing is there, my lord,
Yeah, that was also better. Anyway. Not later. No, that's all.
Hello.
Third, Mr. We are not going into the merits, right?
No, not on the merits.
merits, my lord, otherwise
We are not going
They are
to-
in possession, my
Because
lord.
you have not submission, made any submission also. Let us see these aspects only. Yes, Nawaz Learned Council. Learned additional PP. Invoking 483, have a seat. 483 BNSS, the petitioner seeking regular bail in connection with special NDPS case number 79 of 2025 in the so-and-so section, which is pending before the learned special judge Hojak. Charge has been framed? No.
Charge has been framed, my lord.
He stated that
Charge order is at page 54, my lord.
it is submitted at the bar that charges have already been framed under section 20B2C/29 of the NDPS Act. And the case proceeded to the stage of evidence. The petitioner was arrested on, is stated to have been formally arrested on 24/8/2025. The scan record has been received. The gist of the allegation is about recovery of
23 kg of guns.
23 kg of suspected ganza from the possession of the petitioner. The learned Mr. Nawaz, learned counsel for the petitioner, raises primarily two contentions. Firstly, that though the petitioner was shown to have been formally arrested on 24/3/2025 at 1 p.m. But he was, as reflected in the FIR itself, he was detained by the law enforcing authority on 24/8/2025 at 1:30 a.m. And as per the forwarding report, the remand order was passed by the magistrate on 25/8/2025. Thereby, his production before the learned remand magistrate is exceeded the stipulated 24 hours. And hence, there is a infirmity in his arrest and his continued detention is untenable. The second contention raised by the learned counsel for the petitioner is that while notice under 47 BNSS has been provided, but notice under 48 BNSS was is stated to have been sent by WTMSS, but there is no material about its received by the family member of the petitioner, and therefore there is no compliance with section 48 BNSS, constituting another infirmity in the arrest and making his further detention untenable. The learned additional PP on the basis of the scan record submits that as per the materials produced by him, the IO had sent the notice under 48 electronically. Full stop. The learned additional PPA stated about the serious nature of the allegations and seizure of a large quantity of suspected drugs from the accused. Stuff. In support of his contentions, the learned counsel for the petitioners relied upon the following two cases, following two decisions. Subhash Sharma, this thing. I have perused the relevant materials, considered the rival submissions, and gone through the case laws. This much, huh? Chamber dictation. I want to go through the judgments once properly, applying the mind. Maybe this is a gray area in law, because see, on one hand we are trying to create a legal system where we strongly discourage, hurried arrest, arrest when only if necessary. So for that purpose, sometimes this kind of provision, like in Customs Act, the person is called, and then if arrest has to be done, it has to be after, careful deliberation, thinking, following all the procedural. That will take time. But then what happens to this? What happens? If you expect the investigating authority to take that time, which is good, from one point of view, it's very good. That no hurried arrest, absolutely. That's very good. But suppose he takes time to decide about arrest, but the clock starts ticking the moment he's detained, then there'll be another violation.
In this case, that drug detention kit was not there. Only suspected. In some cases.
So the legal regime also have to provide guidance to the investigating officers, or maybe new laws have to come to provide for this kind of things, because the objective of this law, present interpretation, is safety, because it will be highly risky. As I said, somebody may be detained, kept for 3-4 days, subject to even some custodial violence, then arrested. It will be risky actually. So if you have to have some kind of pre-arrest detention, you have to make your checks and balances. Then only it will be effective. But this is a gray area partly, isn't it? Because you are encouraging slow arrest. That's good. But at the same time, the clock starts running.
But then again, when because it starts from Nazir Ahmed judgment, because when the law prescribes the particular mode of doing a particular
it has to be done that
it has
way.
to be done exactly in that mode. And
I told you, this expression appeals to me. It's an interesting expression.
That language melody.
What did you say?
That part.
Good expression.
Maybe. 36 plus 36 submitted. Page 59 days, 60 days period.
POCSO matter.
POCSO under section 12. POCSO service also, no, service not complete, but success submitted. On 31st of March.
So should we wait for service, or you'll approach trial court?
Better to approach trial court.
Okay, you can. That will save some time probably. The Mr. A. Roshik, learned counsel for additional people. Invoking 483 BNSS, the petitioner is seeking regular bail in connection with Bokaghat PS case number 40 of 26. And so and so he was arrested on 5/3/2026. Service is complete, however.
That report is not available.
No, it's in the office note.
Oh, yes.
Oh, sorry, service report has not been received.
But I have taken a similar as per procedure and immediately.
Item dispatched, not yet received. Completion of service upon the respond number 2/informant is still awaited. Full stop. The learned additional PP submits that in the meantime, the investigation stands completed and has resulted in a charge sheet. Full stop. In view of the aforesaid development and as agreed to by the learned counsel for the petitioner. This petition, bail petition is disposed of with the observation that the petitioner shall be at liberty to approach the learned trial court for regular bail, and upon doing so, the same may be disposed of accordingly, also keeping in mind the stage of the case and after complying with the other procedural formalities.
That charge sheet number may be mentioned.
Yes, CS number.
CS number 36/2025, 2026, sorry, dated 31/3/26.
38.
38 matlab is an interim, but CD is not updated matlab.
It is before the IO, my lord, and statement has already been recorded.
Recorded.
Information is not available matlab.
What are the provisions? What sections?
My lord,
CD has been received.
CD received, but it is matlab up to matlab 27th of January.
Oh, some gap is there.
Earlier there is an order for updated CD matlab, it was not taken back. We have sent the signal matlab.
You want an updated CD?
Updated CD only regarding the information that he has appeared or not matlab. That
According to you, he has appeared. Otherwise, what are the
as far as the statement of the matlab, petitioner matlab,
as such, his petitioner name not in the FIR, my lord. His brother was arrested, my lord, suspected to be the Bangladeshis. And
suspected to be foreign national.
foreigners. I'll kindly see is 18, my
foreign.
lord. And in statement of his brother, the petitioner name appeared in the FIR. Page 18, my lord.
Okay, okay. A reference can be preferred. Yes, sir.
documents were seized.
Okay, you get if you want to get the updated investigation, you know, keep it pending, Mr. Alia, Learned Counsel. The case diary has been received, but it is it is endorsed only till 27/1/2026. So in the meantime, pursuant to grant of interim bail, the petitioner is stated to have appeared as per the learned counsel. However, the prosecution submits that the statement is not recorded as diary pertains to the period prior to that. Oh no, it was earlier given long time back. The statement is also not available. Accordingly, the case diary may be returned back and procured again with the up-to-date investigation, including the statement of the petitioner. The interim bail granted by 13/11/25 stands extended till the next date of list. Please the matter on
22nd May.
All right.
Again. 40.
Up to the 40 matlab substitute submitted.
Petitioner the interim lordship. Is a appear before the IO and his established already recorded lordship. Yeah, then this
Cattle
case-
preservation.
Cattle preservation. He's the registered certificate holder. lordship. And as per rules, lordship, he already thereafter the cattle which was seized in this connection, lordship, is the owner of the said color, and thereafter he approached the learned trial court, GMFC for Zimma. According Zimma also granted. Therefore, section 303/125 this is not attack in this. Yes, I'm also.
He is the owner of the cattle who got
Registered certificate holder, lordship. I have annexed the certificate, lordship.
No.
And when the vehicle was seized during seizure, finally see the seizure list here, no? page 16, Lordship, and 9 number of petrol parcel receipt also seized, and one document certificate of fitness to travel was also the veterinary doctor issued certificate of fitness for that the vehicle is fit to travel. That fitness certificate also seized by the concerned IO here, no? No, thereafter the cattle also.
The documents we have not, no documents to verify, because all this are stated when.
Okay, anyway, I think we can make it absolute, no problem. So you take third.
Islam.
And that's okay. No, and you just you take this order 8/1/2026. Para 2 and 3 you can lift. 2, 3, and 4. Yes, you can. Full stop. It is submitted by the prosecution that in the meantime, investigation stands completed and has resulted in a charge sheet. Full stop. The learned counsel for the petitioner reiterates his earlier submission that he had possessed the cattle by legally, and that in the meantime, the learned court below has also given interim custody of the cattle to him. In any case, in view of the completion of investigation, the interim bail granted to the petitioner by order dated 8/1/26 is hereby made absolute, subject to the condition that he shall cooperate with the trial if one commences and shall not hamper or tamper with it. It's posted.
54.
Write it down. CS number
54/2026, dated 27/2/26.
What's up, Lord?
43.
43, he is an interim up to the CD was called for, but up to the CD not received, he is an interim.
Okay. The up-to-date case diary as called for is not received. Issue reminder for the same. The interim bail granted by 31/3 stands extended till the next date of listing.
22nd of May,
Yes.
45.
Lordship,
Yes, ma'am.
CD has not yet been received, Your Lordship, and I've been told telephonically that they have issued the show cause notice, which is taken into a charge sheet.
Charge sheet. It's called show cause notice.
It's called show cause under 124.
Please, Your Lordship.
On 28th of March, they have issued the show cause. I just received a soft copy, otherwise.
They're on interim bill.
They are on
Interim bill. So we'll call for the show cause notice.
show cause notice. It's very bulky. I've just given. So some time will be granted next week, Your Lordship. And
or you can get the relevant parts of it.
Yes.
Up to you. Relevant parts.
Only the petitioners involved.
Yes, yes. Relevant parts of also you
That
can.
portion.
Heard. The petitioner was granted interim bail on 23/3/2026. First. The case diary has been received, however.
The show cause notice. Now there is no case there because they have already issued the show cause notice.
It is submitted by the Learned Standing Council, DRI.
Your Lordship,
Yes.
has already appeared before the investigating authority.
It is submitted by the Learned Standing Council, DRI, that in the meantime, investigation is completed. And the final form, within bracket, show cause notice has been submitted. And he seeks some time to produce the relevant portions of the same. The prayer is allowed. The Learned Counsel for the petitioner submits that pursuant to grant of interim bail, the petitioner has appeared before the investigating officer.
Yes.
And his statement has been recorded as well. The interim bail stands extended till the next date of listing. List the matter on. Take it as per your convenience.
May, Your Lordship.
Okay, 18/5.
46.
Your Lordship, there is an interim order, Your Lordship.
Yes, I've extended it. Written. Yes.
Oh, nice.
Maybe this is okay.
The Lordship has given me the interim protection to appear before the Judicial Magistrate First Class, where I have appeared, my Lordship. And thereafter, my statement has been recorded by the Judicial Magistrate First Class. The order have been given in the magistrate record, my lord. Yes, because charge sheet has been filed, my lord, and I have appeared before, after getting protection from this honorable court, I have appeared before the Judicial Magistrate, my Lordship.
Okay.
So, my Lordship, I have not violated any condition laid there by this honorable court, my Lordship. And charge sheet also filed, my lord. So, maybe.
You're for the informant.
Yes, Lord.
Whichever, you can also start, whichever, as he'll submit.
Lordship, in this case, perhaps my learned friend was not briefed about the matter by the petitioner, but he was also an accused in a previous murder case. So, Lordship, the brief facts of the case are this, that the present petitioner, along with number of other accused persons, were initially accused in a murder case that was registered at Gauripur PS 3 of 2023. That case is registered as later on as 263 of 2023 in Sessions Court. There, one of the accused persons is the present deceased victim, your lord. So he in that case was caught by the public on being accused that they have committed such and such murder in the previous case, and he was very badly beaten and he had been almost paralyzed, your lordship. On that ground alone, he was granted bail in that case very initially. After that, since he got out, perhaps there was apprehension on the part of the other accused persons that he may spill some secrets that were not supposed to be spilled. And then this present accused, the accused person became the deceased, your lordship. He was murdered by all these accused persons. That is the allegation of this case, your lordship. So that was not pointed out previously, your lordship, and lordship already knows that criminal antecedents have to be pointed out.
Nowadays, it's
Yes,
the law also.
Even Supreme Court in
Innocence.
Ziba Khan versus State of UP has mandated that.
Recent
Yes.
Forgot the name.
2026, your lordship itself.
Lordship.
May I please, your Lordship?
Of course, the advocate may not know, but the litigant has to brief the advocate.
Yes, your lordship. And lordship.
Advocate's duty is to ask him that if you have something, tell me.
Yes, sir,
so that I have to record.
Yes, your lordship. So, your lordship, this is, I also could not find much details over the phone, your lordship, but this is a bail order in the previous case, your lordship, of the present petitioner, lordship.
The present petition.
The present petitioner, your lordship. As lordship already knows, he's already accused in this case. His name is mentioned in the charge sheet.
This is also an AB.
Yes, your lordship. Yes, your lordship.
This is on top of it, it's an AB.
Yes, your lordship.
So let us see.
And second, your lordship, another fact of the case is that subsequent to the filing of this FIR, the victim had filed 2 other FIRs, your lordship, where her life was being threatened and she is being pressurized in order to withdraw this case, your lordship.
May I please, your Lordship?
Yes, I'll come to you.
May I please, your Lordship? As far as my learned friend contention, I have not at all aware of it, my Lordship. But the learned friend, whatever the incident described, regarding the cross affair, this is basically against the Aisha Beva, my Lordship, which have been already granted bail, my Lordship, this honorable court. And thereafter, he got the bail from the judicial.
Which person? This one?
Aisha Beva, whatever the incidents, my Lordship, my learned friend just described about the cross affair, this and that. So my part is my name is, my Lordship, can see in the. One is, my Lordship, Nabikul. Another one is, my Lord, the Nozrul Haq, my Lordship. Regarding the cross affair, everything has been Aisha Begum, who is a lady who filed it, my ladyship, Lordship. Because these things are mentioned in the charge sheet, my Lordship. Whatever the my learned friend said, this is mentioned in the charge sheet. It is against the Aisha Begum, who is a lady, my Lordship. And I am here representing the other 2 co-accused, my Lordship. And no overt action or any specific act mentioned in the charge sheet, my Lordship, against me, my Lord. And other co-accused also granted.
Who's facing threat? Who's facing threat? The informant.
The informant in the present case, your lordship.
That is Lutfa Bibi, your lordship. She is the wife of the deceased.
The deceased who was an accused in the other case.
In the other case, your
Against me.
he was in the other case. Now, your lordship, the
It was
problem.
against the Aisha Begum, my lordship. In the should also mention this fact, my lordship. After the honorable IO investigating the matter, that matter has been closed, my lordship. That is not against me, my lord. It is against the that lady also been granted by this honorable court granted bail. Her name is Aisha Begum, my lord. Aisha Begum, my lord.
No, the informant here is Lutfa Bibi.
And as far as the other accused person, Nazrul Haq, Nazrul Islam, is concerned, your lordship, I am not able to locate him right now, but in the charge sheet given, Nobikul Islam has been clearly implicated, your lordship. He is given as
My lordship.
accused number 9, your lordship. He is
Oil.
clearly implicated. And the bail petitions of some of the other accused persons has also been rejected recently, your lordship. I can procure those orders if your lordship.
Some are also granted by this honorable court. My lordship, as per the petition number 2 is concerned, while the informant lodging the FIR, first his name was not mentioned in the initial FIR, my lordship. After investigation, his name came into this picture, my lordship. So heinous crime, but the informant, while lodging the FIR, petition number 2 name even mentioned. Not even the reference also drawn in the FIR, my lordship, against the petition number 2. Though petition number 1 name is mentioned in the FIR, my lordship, but learned friend, whatever the contention made, that mention against the Aisha Beba, who is the lost the affair, and not against me, my lordship. And though I have already been appeared before the JMFC and I have been cooperating, I have not violated any of the terms and conditions your lordship has.
But
restricted.
threatening aspect. must
Yes,
be
your
seen.
lordship. Threatening aspect is that we have lodged another FIR if your lordship wants to peruse. I can file, otherwise I can bring it on record via an additional affidavit also. All other 2 FIRs have been recorded by us, your lordship. This is the
Okay,
latest
bring-
one.
I think that would be better because otherwise he may also be prejudiced. Because
Yes, yeah, okay.
you bring it on record, he will take further instructions and the other, whatever decision
Yes.
rendered by another bench.
Yes.
Here by this court,
Yes.
by this court,
Not by this court, your lordship.
by
Not by this court.
trial court.
No, by High Court, coordinate bench of the High Court.
Coordinate bench.
Coordinate bench of the High Court.
Entry may be
Or
protected.
should,
my
and
lordship.
that is okay, that will be continued, but then should it be listed before appropriate bench, which are
Your
dealing with
lordship,
other
most-
matters? I'm
As
not
per
saying
my
that.
instruction, your lordship, most of the cases relating to this particular affair have been dealt by the coordinate bench, court number 22, your lordship. As per my instruction, most of the cases have been dealt there. So that in that direction may also be passed. The interim may be extended and then we can continue with the case. I'll file the affidavit. My learned friend will also be apprised of all the developments, your lordship. He can argue there.
The heard learned counsel for the petition. Would you like to say something, Mr.?
Did the, my lord, the record become?
And
Because my
what to
lord
do about
wants
this
to bring some, my lord, to the record,
appropriate
my
bench? Should I?
My lord, if it is dispose of, my lord.
All the matters are, if they are being looked after, being taken up by.
Learned friend's submission that, my lord, others matter relating to the same FIR, my lord, arising of
Lordship can peruse. These are
already
both
dispose of,
from
my lord.
the same FIR.
Ideally, one affair should be one bench, but we
Yes,
still
yes.
don't have that system.
Yes,
We
sir.
still don't have that system, but it's ideally it's like that. One day it will happen.
Different petitioners in the same FIR, your lordship.
Anyway, so I leave that to you. You guide me regarding that appropriate bench, but other things I can pass. The petitioner was granted interim bail on 30/3/2026. It is submitted that pursuant thereof, he has appeared before the court of the learned JMFC, and that the case is pending committal, right? The scan record has been received, full stop. It is submitted by the learned counsel for to inform that the informant has been facing threats from the side of the accused, over which 2 complaints have already been lodged, and he may, and given an opportunity, he may like to bring the same on record through an additional affidavit. The prayer is allowed. The learned counsel for the petitioner also seeks to take some instructions, additional instructions from the petitioner side. Full stop. What about appropriate bench? Appropriate bench. Order, list the matter before the appropriate bench, which has dealt with the other bail petitions arising out of this. We can get that done actually. Nowadays it's very easy with technology. We can get it done.
It generally happens automatically.
We can make it absolutely formal. Bar has to just take it up. That will be very good for both sides.
47.
Next day.
Take that interim bail stands extended till the next date of listing. List on, you tell me how much time it should be fixed after. No, let it be not this week, thereafter.
No issues. It can be on 18th, 19th.
Okay.
Able to.
If loveless, no.
What is that? Please, Your Lordship. Actually, this is 482 pre-arrest bail application, Lordship.
I understand.
The charge sheet has already been filed. This is an affair of March 2024. In the charge sheet, Lordship, I have been shown as an absconder, Lordship. And I have received the summon from the special judge.
Here, my lord, the notice is awaited, my lord. Notice is awaited because POCSO matter, my lord.
Yeah, so then.
ECR was also called for, Lordship.
Come.
PCR received, my lord, but my lord, that is notice is awaited. My lord.
I'm ready to appear, Lordship, before the all the other before the learned trial court and face the trial. All the other accused are on bail, Lordship.
Kindly take instructions.
My lord.
He will take instructions regarding the service so that we can appoint an amicus.
Yes.
Stop. The scan TCR has been received, fixed up. However, service report not received from received with regard to respondent number 2/informant. The prosecution shall take instructions regarding service upon the informant. List the matter on.
Next week, is it?
Yes, sir.
14, 15, 14,
Next day to be clear.
14.
In 1905.
Then my lord, this week itself, my lord, then.
You want it?
Next, I want to appear before the next date is 1905, Lordship.
We'll give it before.
Then my lord.
Then give it early next week.
Yes, my lord. Then
12, 13.
My lord, 7, my lord. 7 of this week.
Give it on 5th, 11th.
11, my lord.
Lordship.
Because my lord, yes, 11.
11th.
11.
Hello. I'm being at 22.
My lord, I'm not been able to hear the first call.
No problem. This is basically a quashing petition. Is it a quashing petition? Government advocate has been noticed.
There is no need for government advocate. I'm just explaining. Here I'm seeking quashing of the initiation of the proclamation proceeding and the resultant proclamation order declaring me as a absconder by a court at Panipat, Haryana. By a court in Haryana. Can you see the last order, first order?
Just last order.
First order. Initial order.
Show of jurisdiction.
The question is
State is not
whether state should be a party here.
Show of maintainability. The state is not being made a party.
And we are basically seeking a writ of certiorari. And certiorari is issued by the Constitutional Court to the lower court and the tribunal to correct any jurisdictional error or error apparent on the face of the record. Just settle law.
Okay.
So
why not a criminal petition? You can file a repetition criminal also.
That's my choice, my lord. That's my choice. Now,
but sometimes the prosecutor becomes necessary in a criminal case.
Under 220.
That is the only problem.
I will show from the record, impugn order, my lord. It is
ex facie wrong order. Ex facie wrong order.
But who's the respondent here? Raj Kalra.
It is arises out of a complaint petition under 138.
Have you issued notice to him?
No.
Why?
Notice is yet to be issued, my lord.
Okay.
Notice is issued.
Oh, okay. So, okay, let me explore.
Yes,
We can enter whatever you're trying to say to.
Yes. Regarding maintainability under 226(2), it is absolutely clear. If a part of cause of action arises within the jurisdiction of this court, then this court has the jurisdiction. Even if that order has been passed from a place outside the territorial jurisdiction of this court, it is settled law.
Right.
Now, this is not the first round of litigation. In fact, this is the second round of litigation.
So anyway, so impugn order, which part should we see?
I will come to that. Can you see page 41? Is it an order by which section 84 was invoked? Can you see this order? Non-bailable warrant issued to the accused not received back. Therefore, I am satisfied that accused is intentionally avoiding the service of warrant and presence of the accused person cannot be secured through ordinary process. Hence proclamation. Issuance of proclamation is a serious matter.
There has to be what we have learned is that there has to be a process, execution.
Absolutely no. The reason, can you see the reason?
DNA report.
Not bailable warrant received back. And therefore, this presumption was drawn. Can you see section 84 of the BNSS? Just for a moment, see BNSS come there.
Sure. Now it is 64.
Now this is 84, my lord.
84.
84. May I read? It says, if any court has reason to believe, whether after taking evidence or not, that any person against whom a warrant has been issued by it has absconded or is concealing himself so that such warrant cannot be executed, such court may publish a written proclamation requiring him to appear at a specified place and a specified time, not less than 30 days from the date of publishing such proclamation. It says reason to believe. Now this
with or without taking evidence also.
Yes.
But usually we do, but it seems statutorily it is not necessary.
Reason to believe has a definite legal connotation. Subsection 29 of section 2.
The content of this, it has not undergone any change after.
No, absolutely nothing. Absolutely nothing. Now,
reason to believe.
Reason to believe has been statutorily explained. Subsection 29 of section 2 of the BNS explain it. This expression. It says sufficient cause to believe. Now, this sufficient cause cannot be derived in vacuum. There must be some material on which this reason to believe is to be founded. It's a settled law now. There must be reason for drawing this belief, and this reason must be reflected in the order. It's a settled law. Now here, simply because warrant has been returned back, 84 was initiated. Allow me to just refer one judgment of our High Court, exactly on identical facts.
Okay, that's okay. But yeah, it seems that you have to be satisfied on the basis of the NBWA report.
Absolutely.
That why it was not solved.
Absolutely.
Not because it is not received back. then that
Absolutely.
prima facie maybe.
No report.
Maybe
No
that
report.
reasonable satisfaction maybe. Now, next thing we have to see is the jurisdiction aspect,
Yes.
right?
Yes.
Jurisdiction aspect.
Yes.
One part of the jurisdiction arises within the territorial limits of this.
Yes,
court,
yes,
right?
yes. No.
So kindly let us see this, see that aspect.
This is the second round of litigation. Earlier, we have filed another criminal writ petition. That's the order. And notice was issued.
Okay.
এখনো divorce. Can you see para 7, 8, and 10 of this judgment? This is from our High Court, arising out of 138 proceedings. Para 7, 8, and 10.
Para 7, 8, and 10.
10. Where jurisdictional part was clarified.
Yes. If a cause of action, yeah, that is settled. Cause of action has to arise
Can
in
you see
part.
para 10? Para 10.
This was pertaining to another check. This was
Different check.
different check.
Different check, different case. But arising out of 138. Now, in my case, the check was admittedly drawn at Gauhati.
Just a minute, let me say this. Fine. Here, now we come back to the facts of this.
In our case, the check was drawn at Gauhati. It was rejected in Gauhati and also presented in Gauhati.
Oh.
So cause of action arises.
Dishonored in Gauhati.
Dishonored in Gauhati by bank in Gauhati. It was drawn at Gauhati. And because of that, in the earlier case, notice was issued.
Presented in Gauhati as well.
Yes.
Okay.
Squarely covered by para 10.
In check bouncing cases, of course, now after that judgment, it's been quite a while since that judgment.
Yes, yes.
What was the name?
Yes, yes, yes.
That it put an end to the confusions. No?
Absolutely.
In BRR check, wherever it is dishonored, or the payee has an account.
Yes, yes.
Anipat. We can issue notice at this stage, and
I'm praying for staying of page 44, man.
that we can consider.
Page 40 was specifically because apparently, if 41 goes, 42 also goes for the same reason. I will show why 42, 44 is bad. Apparently bad. Sorry, 45.
Or they already declared proclaimed absconder.
Can you see? Can you see this? This is the written proclamation. Can you test page 44 on this in the light of that? That's the written proclamation. See the date when I'm supposed to appear. 21.
by this proclamation, I was called upon to appear on 21, 2026, published on, admittedly, on 3rd January. So no clear 30 days. See the and 43 is the proclamation report submitted by the process server. It was published on 3/1. Now, can you see page 42 order? Page 42 order.
United Bank of India, Ulubari, right?
Yes.
Favor of the complainant. And it was presented at
Yes,
this place,
yes.
at Gauhati.
Yes.
No, it was presented in Panipat, I think. State Bank of India, Pani.
That
After
was
it's been-
presented by,
But it was to the
Yes,
surprise of the complaint.
it was drawn at Guwahati.
In check bouncing matter, however, there is another dimension. The territorial jurisdiction aspect will also be determined by that law, which was laid down, right? That decision. What was the name of that case? I forgot. It was a very leading case. And thereafter the amendment was made. No?
Yes.
It was,
Yes.
it was issued in Gauhati, but presented in Panipat. And these are not there. These are not there, obviously. You said rejected in Gauhati and presented in Gauhati. That's not correct. I think it was only drawn in Gauhati.
Drawn in Guwahati.
Drawn in Gauhati. Only drawn in Gauhati.
Rejected by a bank at Guwahati.
No, at Panipat, I think.
That Droy Bank is at Guwahati, presented in his banker, but drawn at, can you see page 10 of that order? I've just referred to. Cake will be rejected by the Droy Bank.
Yes.
Bank was at Guwahati.
The account was here, no?
Yes. So the bank
Alleged insufficiency of funds was at Gauhati.
Guwahati.
That's
At Guwahati. The Supreme Court, even a tiny cause of action, appearance of cause of action will give.
Enact. Let us refresh this once. In case of account pay check, that means if the check is delivered for collection through an account, the branch of the bank where the payee or holder in due course maintains the account. In case of an account pay check.
That for the complaint case, for institution of the complaint case.
Complaint case.
That's for institution of the complaint case.
No, but if a check bouncing proceeding is sought to be quashed, in a high court. So that will have the jurisdiction of the high court will have some bearing with the jurisdiction of the trial court also, isn't it?
Yes.
Check bouncing proceeding of Rajasthan lying solely within the jurisdiction of Rajasthan or say good anyway cannot be quashed by Gauhati High Court and vice versa, right? So you are coming here because you think that,
Some part of cause of
Yes.
action arises within the
yeah,
jurisdiction.
but
Now, my lord, there are 5 concomitants of 138 offense.
yeah, that's true. We are on the territorial jurisdiction. Come to you, if you have this thing, 142 subsection 2, which was inserted after that judgment.
Ha ha ha.
Check is delivered for
Yes,
collection
yes.
through an account. The branch where the payee has an account. That means it's an account pay check, it will be in Haryana.
Huh.
Suppose pay, or if the check is presented for payment by the payee or holder in due course, otherwise to an account, the branch of the drawee bank where the drawer maintains the account is situated.
It was brought in just to nullify the Supreme Court judgment.
No, the earlier
Otherwise,
judgment,
it says,
no, the earlier judgment was it led to a lot of confusion.
huh,
Thereafter, there was another judgment
absolutely,
which
absolutely.
corrected that.
Yes, yes.
Thereafter, this amendment was
Amendment
made,
came, yes. Amendment came.
giving statutory support to that
Yes,
interpretation.
yes, absolutely, absolutely.
Anyway, this part I have to see a little bit. Otherwise, you issue notice. Stay part I will have to, because jurisdiction I'll have to study again. Seems I have to study a little bit. Otherwise, your prayer is that issue notice.
At least for the next returnable
Your
debt.
prayer at this stage is that it may be stayed and issue notice.
Issue notice and staying page 40, 45. 45 may be stayed till returnable date. Let them come and appear.
No, that the jurisdiction has to be seen, right? If you can file, could the check bouncing proceeding have been filed in Gauhati? That's the question. That is the question. Could the check bouncing in terms of 148 to this provision, in terms of section 142 subsection 2 of the NI Act, could the check bouncing proceeding have been filed in Gauhati? That's the question. If yes, then we have jurisdiction. If no, then I'm afraid maybe not. So that aspect may be gone into, if I understood correctly. What do you say?
That I have to examine. I have to apply my mind to that aspect.
Can take another date if necessary.
So notice may be issued in the meantime.
Notice can be issued. For the stay, we can have another.
Stay may be kept open for the next returnable date.
Yes. You can take a short date, no problem. Just sometimes it's better rather than make a wrong order.
I go down to
Yeah, no issue. You guide me and both of us will work on
yes,
it.
yes.
Because the language from the beginning, ever since I encountered this, though the judgment addressed the confusion and subsequently this was, the framing of this language is also not very clear.
Absolutely.
It's little confusing. Anyway, that will be best. Otherwise, this much I am convinced that mere non-returning of NPW cannot be enough. Otherwise, we take a lot of steps.
Yes.
That we examine EO and then we do a lot of homework before.
This says notice may go and my interim prayer may be considered, my left open.
Left open. In the meantime, you can do a little bit of homework.
Yes, sure.
You can read up. And then I think I am not wrong in saying that we have to address that question that in terms of this, the territorial jurisdiction law, check bouncing, could the complaint have been filed before CJM come out? So then we'll have jurisdiction. Suppose we come to the conclusion that we cannot be filed at all. It has to be in Haryana only. Then perhaps we may not have. Then we may have to seek your remedies there, maybe.
I will try to show that we can also file here also.
That you kindly explore and check it. Third, learned counsel for the petitioner, who has filed the writ petition on the criminal side seeking writ of certiorari with regard to order dated 21/4/2022. Sorry, order dated 19/12/2022. And order dated 21/2/2026, whereby proclamation was issued against the petitioner under section 84 of BNS and by the subsequent order after purported due publication, he was declared as a proclaimed absconder. Full stop. Learned counsel submits that the dispute has arisen out of a alleged dishonor of a check issued by the petitioner, purportedly issued by the petitioner, drawn on United Bank of India, Ulubari branch, Gauhati, in favor of the respondent number 2 / respondent, sole respondent / complainant. Full stop. Learned counsel submits that as the check was drawn up on the bank of the petitioner located at Gauhati, therefore, this court would have jurisdiction to entertain this petition in terms of Article 226(2) of the Constitution of India. Further, it is submitted by the learned counsel and that the issuance of the proclamation is not at all based on reasonable satisfaction of the learned trial court as required under Section 84 of the BNSS. Stop. Issue notice upon the sole respondent. Speed post, you can take steps by speed post. Full stop. With regard to the prayer for stay of further proceedings, it is a query is raised by this court as to whether, in terms of the law under Section 142, subsection 2 of the NI Act 1881, the complaint could have been filed in Gauhati as well, so as to decide the aspect of jurisdiction of this court. Full stop. On that issue, the learned counsel takes some time to place his contentions and submissions. Full stop. Therefore, the prayer for interim bail, prayer for interim order by way of stay of the impugned orders is kept open. Full stop. List on. You take the steps in the meantime. Take the steps in the meantime.
After 2 weeks?
No problem. No issues. List after, it will be better to fix a date, I think. List after
Fixed
2
date will
weeks
be better.
on for 18. 19? 19 May? 19 May? 19 or 20 May?
Just
check your diary.
Let me check. (22), if that is convenient to this court.
22.
Much.
149.
We continue going. Sort of a short bus. Can you go there? Yes, leave petition.
Leave petition.
You are appearing for the acquitted person.
Respondent number.
Acquitted person.
File objection, written objection.
Against the leave.
Right.
Against the prayer for leave.
2 years time may be granted for filing a written objection.
The instant leave petition has come up for adjudication of the question of leave sought for by the petitioner applicant seeking to file a criminal appeal against acquittal against judgment of acquittal dated 15/7/2025 in NI case number 82 of 22 passed by the learned SDGM S. Dibrugarh. Full stop. You are Mr. Nag.
D. Sharma.
MB.
N. D. Sharma.
N. D. Sharma, learned counsel for the respondent number 2, within bracket, acquitted person, 2 weeks time to file an objection. The prayer is allowed. List the matter after 2 weeks.
Date
Maybe 20. Chocolate. Mommy. Just 2-3 minutes.
sir.
50.
Non-APS delay condemnation.
Non-APS today on behalf of the applicant. List the matter after 3 weeks. After 3 weeks. On a date to be fixed by registry. Yes, ma'am.
Please, Your Lordship. Lordship, as per office note, Lordship, service report is awaiting.
This is the delay condonation.
Delay condonation, Lordship. Earlier also we have taken steps, but
Okay.
this has not been returned as answered.
Village.
This time, second time, Lordship.
Okay. What do you suggest? Should we wait or?
Otherwise, from our side, it is statutory appeal don't have any objection, but this is
Private
matrimonial issue, yes. Matrimonial issue,
No, matrimonial issue.
yes,
Then
yes,
it is
because
better
of
to.
that,
It will be procedural. Regulated. So we can wait or fresh steps. Fresh steps you have already taken.
We can wait, Lordship.
Can wait.
wait service.
The Decca Learned Counsel for the petitioner submits that service report with regard to respondent number 2 is awaited, though steps have already been taken. Is okay. Is the matter after how long? 3 weeks?
Date may be fixed, Lordship.
Is the matter after 3 weeks on 26/5? 26/5. Yes, Mr. Mondal.
May I please, Your Lordship? Lordship, I for bail, Lordship, and more than 3 years in behind the jail, Lordship, and allegation is POCSO 7 years, Lordship. And
It's a IA for bail, I have not gone through the PCI, in any day,
You're for the informant?
is for the.
Lordship, on behalf of informant respondent.
Informant.
And we have not received copy of the IA.
Can you give him a copy?
Yes, Lordship.
Fix another day. In the meantime, you can go to, if you have to see on merits, then you have to.
Kindly এটা কপি আমাকে দিবেন না।
And on behalf of respondent number 2 informant, will file objection, Lordship.
Your file.
Lordship.
Stop.
No, they will file,
Lordship.
not yet file.
You'll file.
Yes.
For the applicant. This IA has been filed for suspension of sentence and bail with regard to impugned judgment and order dated 11/1/2023 passed by the learned special judge POCSO Dhubri in special case number 69 of 2017. The applicant has been sentenced to a substantive sentence of 7 years, rigorous imprisonment. The learned counsel appearing for respondent number 2 submits that he would file a written objection against the prayer for suspension of sentence. The learned additional PP also seeks some time to go through the file. Both the prayers are allowed, full stop. List the matter after. It is submitted that copies may be furnished to the other side, full stop. The petitioner side shall do the needful. List the matter after
Kindly fix date, Lordship.
I'll fix it.
Any date.
Twenty-eight.
Obliged, Lordship. Obliged. Highly obliged, Lordship.
But 53 with all respect, my lord, earlier that IA was rejected by coordinate bench, my lord.
Okay. Suspension of sentence.
My lord,
No,
yes.
but it was all, this is the second,
Second,
IA
second
matter.
time, earlier IA was rejected by Justice Sharma, my lord.
It has to be sent there.
My lord.
I guess.
That's annexed at page 66, my lord.
1909. Quite a long time has elapsed. Should I, learned senior counsel? Should I
Put
fix it
the
before that?
appropriate bench, man. With a date on 20, this time, what's your comfortable date, you said?
27.
Madam Devi, you are appearing for the legal aid counsel.
Legal aid.
But learned senior counsel, Jet Kumar, LPP, and L Devi, learned for number 2. Full stop. The learned prosecution is pointed out that an earlier application for suspension of sentences bail was rejected by coordinate bench. Full stop. Right order dated so and so. 19/9/2020. I criminal 398 of 24. This is the matter before the appropriate bench.
On
Any-
20, my lord.
Any order to be passed in the main criminal appeal?
Oh, not that one, sorry.
Only the date may kindly be fixed, my
Yes,
lord.
I'll fix the date. You can suggest a date.
On 20.
20?
Much of it.
I think item 54.
What is the matter? Last item is hearing.
Hearing.
Lordship, can it be taken any other day, Lordship?
Another day. No problem. Should we fix it on a Tuesday or Thursday? That will be better. That's 20, it's 20 recent matter.
Recent matter, 26.
Recent matter. But there is an interim order also, however. Scan record in the meantime. Okay, no problem. We'll adjourn it, but we'll do some homework in between. I see. Scan record has. The learned counsel for the petitioner. Your good name, please.
SR Majabhuya.
Appearing for the petitioner seeks an adjournment. Praise for listing the matter on another date. So in the meantime, TCR has been received full stop. You are representing respond number 2. I think. The in terms of order dated 23/3/2026, the prosecution is also representing the respondent number 2, who is a police officer. The interim order, right order dated 27/1/2026, stands extended till the next date of listing. List on any preferred date, you have? Towards it's a new matter, so towards the end of May. Stay is also. Stay is there with the problem.
Here in this case, my lord, his informant, my lord, accused informant, my lord, according to my lord, the IO, my lord, she filed false case, therefore, my lord, his counter, my lord, complaint was filed.
It will be on 3rd June. 3/6. After a month. I don't know.